extension of interim order. ঠিক আছে আর কোনটা কল করো না না 10:30 একটা কল করো yes why is it why did no why is it fixed at 10:30 Mr. Rai?
Last occasion they did not produce the report, that's why
regarding just
relates
refresh my memory
of Anganwadi worker. If the CDPO passed a reason order, your lordship directed my learned friend to produce the report why the selection process has not been completed.
What's that 2009-11
yes in the reason order they have stated that due to the signature of the other expert committee the selection could not be completed, although written test was held but interview could not be held. It was the records.
So what is the present situation, present status?
So they can say,
is that selection process over or is it still cancelled? So you'll have a new selection process.
They have not initiated anything else.
You participate in the new selection.
They have not initiated anything else.
They have. Is that your prayer? Well, show me your prayer that they will they'll be directed to initiate.
We prayed for set aside and cost of the.
That is already done because it's rejected. Yes. That process has already been rejected. Then so PC goes.
I prayed for to hold the viva vocis in the prayer C.
No, C's you are asking for interview on the basis of 2011 examination.
My lord,
that has gone.
My lord, in this repetition, my lord, what I have challenged the reason order itself.
That then let them file affidavits. My lord, reason order can't be just.
They have used this report. My
lord, let them file an affidavit. You're just precipitating issues for no reason at all. When will you initiate the new process?
Nothing else.
Wait now. There's nothing. File affidavits. Ashun, the report filed by the state respondents is kept on record. Stop. If an exception is to be filed thereto, let the same be filed by April 20th, 2026. Stop. On the prayer of the learned advocate for the state respondents, let affidavit in opposition be filed by April 25th, 2026. Reply thereto by May 10th, 2026. List this matter under the heading hearing in the monthly combined list of June 2026. On record, bollam to report filed by the be kept on record. Take it. Yes. হ্যাঁ ঠিক আছে তো না রেকর্ড করার আগে কি অর্ডার আছে কোন তাহলে উপরে অ্যাফিডেভিট অফ সার্ভিস হ্যাজ ফাইল বি কেপ্ট অন রেকর্ড দিয়ে তারপরে যেতে হবে yes yes
with the leave of my learned senior I had mentioned this matter yesterday. This matter was running.
For extension of interim order.
Matter was running in your lordship.
Where's the respondent? Yes.
Objection, my lord. This is a case of 2019, my lord. They are extended the time and related to SLST matter, my lord. And now they are
the SLST matter
related to SLST, but they are producing as if
it's an assignment.
On the related to, my lord, this entire
it's assigned, Mr. Palchudhuri. Is that's your best point too? That's your best point. So I'll deal with it.
Basically, my lord, there are 3 points they are agitating. My lord, that is thing is there, my lord. So that matter running from 2019. So any date, my lord, otherwise because they extended, they are getting the extension.
What is the interim order?
Kindly takes the 13-2 proceeding as well as subsequent sale notices also been stated.
It wouldn't have survived before me.
28th of November 2025, your lordship has first taken this up.
Yes.
8th of November 2025. And my lord, what I have gathered.
No. What is the interim order of 1st July?
First was my lord, stay of the entire the 13-2 process
Yeah.
stayed
Why was it stayed?
because of on the ground of limitation. They had filed a suit.
Round of limitation.
Yes, they are.
Mr. Chaudhary, go before the DRT.
No, they had filed a suit.
So you go before
that-
the DRT.
Malad kindly says takes this, Malad. They have filed a suit that got dismissed for default. After the expiry of the entire period of limitation, they had taken out.
Arey, you go
proceeding.
before the DRT, na?
But we have.
You can't keep enjoying the interim order for eternity.
No. Your lordship has fixed this matter. We are ready with this matter, but not today. But any.
So I'll give you the liberty to go before the DRT. You are the borrower. You are the borrower.
Milord, the DRT have no jurisdiction to intervene. Because Milord, this is the beyond service act. I will place Milord. That is why the
Who will decide? Who will decide whether it's
court will decide.
REET court will decide. You satisfy me on that on the next day. Whether DRT will have jurisdiction or not, the REET court will decide. You satisfy me on this. The interim order passed on July 1, 2019, extended from time to time, lastly on November 28, 2025, is subsisting and will expire on. It is already expired.
Thereafter, Malad, 21st of January 2026.
Your lordship
Last-
extended the
Acha, is subsisting till today. That is January 31st, 2026. Stop. March 31st, 2026. Next, let the interim order continue. The interim order is extended till June 30th, 2026 or until further orders, whichever is earlier. List this matter under the heading specially assigned for hearing in the monthly combined list of June 2026. Thirty, 30. Here.
But I am sorry to inform to your lordship, Mr. Sudeep Pal Chaudhary appeared in this matter on behalf of the bank. Yes.
I Yes.
Bangla appear on behalf of the respondent number 6 and 7.
Mr. Panda, I have foisted some responsibilities on you. Please do that.
But this was, my lord, your lordship.
I couldn't find a more appropriate person to. Yes. Yes, Mr. Mukherjee.
Yesterday, my lord, I mentioned this matter.
Yes.
Lordship, my lord's order.
Why is it appearing as to be mentioned?
Yesterday, I mentioned my lord's order. Your lordship can see my lord's order.
Of 17th February.
It was appearing, yes. My lord, the order of 19th of February. My lord's order is that nothing has no steps, but they as because it's
Yes. Of the petition. Yes. Yes, disposed of. Oh. Consider fresh.
to my lord's corrections, my lord's order, which was disposed of, that in respect of another notice, your lordship can see. And my lord's order is lordship can see the date of the no. This was the decisions, my lord, adopted by the college in their general body meeting, and that was communicated to them for asking the post permission for filling up the vacancy. But that was not taken up. And that's my lord's order. Your lordship.
Where is that 3rd March or
Yes, my lord, I am placing my lord, that date, the notice dated, my lord, the communications from the chunk. Placing my lord. That page.
Yes, Mr. Mukherjee, which one?
My
Where-
lord,
Where is 3rd August 22?
my lord, I am not seeing that, my lord. That is at page.
Yes, page 18.
My lord. These, my lord, in respect of permission to post, that was not done. And that has been taken up by the college, by their general body, governing body.
No, but this page 20.
That is another aspect.
Oh,
That
oh, page 24 is a subsequent communication of 3rd of March.
Ma'am, that in respect the person who has been, my lord, entrusted in furtherance of his, he has been entrusted.
Pull up there.
Yes, my lord, he has been entrusted.
Yes, so that's the petitioner.
Yes, but that is not the prayer at all here. My lord, prayer is that whether unless they grant me the permission for post filling, vacancy filling. So
No,
unless that
who are
has
you?
been-
You are not the college.
No, my lord, I am the petitioner.
So you are the petitioner. Your grievance has been addressed.
No, that is not my grievance. My grievance, your lordship, can you see? My grievance is that unless they, my lord, the DPI, but the college is, my lord, also the respondent.
Yes.
Here. And my lord, on last occasions, your lordship directed, let them take a decision. The DPI should take a decision in respect of the communication made by the college. Praying for, yes, that the decision in respect of third, my lord,
Mr. Panda,
August 20
Mr. Panda,
not been taken at
Mr. Panda, that you take a decision in respect. Oh, Mr. Mukherjee,
my
you take a decision in respect of 3rd August 22, whether they can fill up the post of the cashier, and then they'll take the requisite steps. Yes.
2022, my lord, we cannot fill up vacancies under 2017, which they were claiming, because that is under challenge before this honorable court. So we are not in a position to do that.
So then what happens?
So I can file a short report.
No, but what happens then if the college can't fill up that post?
In spite of the appeals remaining pending, if your lordship directs, we shall.
No. So what happens to the post of cashier? That's what I'm trying to find out.
It is being done from
They-
2022. Let it.
Yes, but if the college can't fill up that vacancy, what happens? What is the consequence?
Consequences, difficulty running the college. That I understand.
So why don't you allow the college? Why don't you allow the college to appoint this petitioner as the cashier?
So they have written to the DPI. DPI has said that the earlier notification is under challenge. 2020.
No, on a temporary basis.
Temporary basis, as your lordship kindly observes.
Mr. Mukherjee, since that is under challenge,
The problem is this, my lord, so for my instruction, when the thing, he is working there. And temporary basis, the salary.
no, but then it can't be done because that notification is under challenge.
Salary which has been
Then,
disbursed, not yet been disbursed, but if this.
so that's a separate issue. Now you're going into a completely different issue.
Because who will pay?
That is not the prayer also.
That is not your prayer, Mr.
The
Mukherjee.
salary cannot be paid by the college.
That can't be helped. Your choice, because that's not your prayer.
The other thing, my
I
lord,
can direct them at best to consider your representation, or you make a fresh representation, which will be considered a fresh and for the post of
but they are
accountant,
my,
cashier. Sorry.
maybe what they are saying, that is neither here nor there. Well, let them,
Mr. Mukherjee,
let them say it because of the challenge made before the this is pending before the.
I'll record it.
Well,
I'll record that.
that is neither here. Well, this is not on record, but this is not on the basis.
Then,
of-
Mr. Panda, you file a report.
Let them file the report. That's why. Yes.
Mr. Panda, appearing for the respondent authorities, seeks leave to file a report as to why the notification guiding the appointment of a cashier in the college cannot be given effect to. Stop. Let such report be filed by April 30th, 2026. Exception thereto be filed by May 15, 2026. List this matter in the on June 12th. June 12 under the same heading.
But since the promotional, so this cannot be created with the post.
Let them file.
Yes,
Getting
Yes.
salary as a librarian.
yes.
Let them file the report, then we'll see. Mr. Panda covered this portion also in the report. Yes. Bado. 30th. April 30th, May 15th, June 12th. Yes.
Since
Timelines have gone for a toss. Yes, just file the notes and give me a convenient date
But only
for
one.
everybody.
Last direction of your lordship was to file written note
Yes,
and also list of judgments.
yes.
I have prepared the written note in two categories. There are fundamentally many matters,
Doesn't
but
matter,
categories
doesn't
are only two.
Yes, yes.
So I've just given two categories.
Very well.
Now, the list of dates, my lord, I have not given. There is a reason. Because there is a
That's
fundamental.
all right. If you have not given, you have not given.
Because if the fundamental point goes, we may not be required as
Very well,
respondents
very
to
well.
give.
Very well.
But 3 to 11 is one category.
Very well.
3 to 11 is one category.
Yes.
But there I am only one preliminary written notes I am giving.
Yes, it's preliminary.
Both are.
I will, if required, I'll permit all of you to
Yes,
file a
In the case
consolidated
notes I have
note.
given it.
Yes.
And then
Same.
Hello. And so far, my lord, 12 to 17 is in another category. That is 12 to
Mr.
17.
Bandhavadhyay, just indicate in your note that
I have given.
My lord, may I say, I think Lubana is one category. Lubana
yes,
Lubana is one category
Yes.
and Probir Mita is the another category. So that's all.
He will not allow to argue, to speak any matter to anyone. It is difficult for him.
So
And any matter he has to speak first.
But he has managed to derail
No,
you.
it is any matter and nobody will be allowed. No, it's all right.
I
You
love-
give
I
respect.
love this
No, no,
part
you
of
rest-
Mr.
No,
Bandhavadhyay.
Mr. Dor, you must give respect to the seniors. You may be senior advocate, but this senior advocates must be given respect.
Yes.
Give it nowadays. When a
That you're
senior,
right.
when a senior advocate is speaking, when you have become senior? I have become senior in 2003.
Mr. Bandhavadhyay, let's take it on a
every
light.
matter he does it.
Let's
And
take
every
it.
matter I have
Let's
to say this.
take it on a light.
I am telling you a lot.
Yes.
He has to speak. Every matter he has.
Correct. He doesn't get the podium like you do.
No,
He has to speak.
11 is the one category I have said to you a lot.
Yes.
And 12 to 17 is the another category.
Just indicate in
I'm indicating. These are the preliminary notes I am giving with the case laws, but I will develop it later.
Of course, of
My lord.
course. So
And-
in your 3 to 11, let us take Lubana Parvin to be the lead matter.
Yes.
You just mentioned Lubana Parvin, lead matter.
No, we
And-
have given.
And from 12 to 17,
Probir Vidya.
this is
uh,
probably
Yes, Probir Mita.
item number
12 to 17.
12. So just mention that Probir
Probir
Vidya,
Vidya.
we'll take that as the lead matter in the second set.
Yes, yes.
Probir Vidya. This is I have given it.
But I have mentioned one is Lubana, another is Probir Mita.
Yes.
They are
Yes,
the-
please file your notes. Now tell me your convenient dates.
So far my part is concerned after election. After
Yes, I
6.
think Mr. Bhattacharya also will not be.
Mr. Bhattacharya was, we had our conference with Mr. Bhattacharya for 8, 9, 10. Now that if your lordship wants, my lord,
We have no problem.
subject to your lordship's convenience, any date.
After 29th, any day we have no con.
29th.
No. After 29th, we have lot of works to do. After 29th, 4th is the counting. We have lot of lot of works I have to do.
Yes,
Now,
sir,
my lord,
we are not bargaining with dates because any day, my lord. Because of that, my lord.
No, I have no difficulties. After 4th, after 4th May. After 4th
Any day.
4th of May is in the middle.
I
Just
have no problem.
but kindly do not keep it on Monday and Friday.
You see,
4th April is the
if I keep
Saturday?
it the second week,
4th,
we are
4th
so-
May is
we are
the
absolutely
Monday.
close to the vacation. I can't clog up the list. a
Now,
week
my lord, I
before-
leave it. I leave it
a
to
week
you.
before vacation.
My lord.
My suggestion is this: come back in June, and
Yes,
I give
one
you-
go in one day to day. basis.
but only thing is, Mr. Kaur, for you also, 8, 9, 10th, I had fixed 3
Nine-
days, 3 whole days.
9, 10, 11th.
No, I had fixed 8, 9, 10th in April. I had said from 10:30. That will create some problem in the list.
Yes.
So we'll take half a day from 2 p.m. whenever in June, whenever from 2 p.m.
Very nice.
Yes, my lord.
So give me some convenient dates.
My lord, June, we are opening on 8th. Kindly keep it on 9th. I have no difficulties if it is convenient to a lot. So 9, 10, 11. And initially, my lord, there will be less pressure after vacation. Initially. First 7 days is less pressure.
Actually require some acclimatization.
So that will be done. For the senior advocate, this is not needed. 9, 10, 11 is good. If anyone doesn't go to foreign country, then it is all right.
No, I'm not going to a foreign.
No, I am saying amongst us. And in fact, whenever the holidays are there, report is this, Calcutta High Court lawyers are almost in foreign countries.
I'll not be there till the 22nd.
22nd?
2nd.
22nd means? Huh? 19, 11. Up to 22nd, your lordship will not be here. After 22nd June,
I'll be on circuit in Port Blair.
whenever it is convenient to your lordship.
As my lord, when my lord, because
Yes,
already
we can do it 20, let's say 30th June, 30th, 1st, 2nd. 3.
Very nice, very nice.
30th, 1st and 6th.
So, my lord, no problem. At 2 p.m.
At 2 p.m. Yes, Mr. Yes. Yes.
I think not the stand of the state might stand.
No, stand up the
Very well.
SSC, not the SSC.
Sorry. Yes, it might stand. But in case I must add anything after the.
Yes, absolutely. Absolutely. I'm not going to stop anybody. You feel free to.
This court gives a fair hearing.
Better watch it.
No, I'm not saying.
No, I'm telling him. Very well.
So, আমাদের অপোজিশন দেওয়া চান না
Yes.
Parents will speak, then the other added, padded, etc. will speak.
I don't know if he's added, but he's certainly not padded for the moment.
No, first parents will speak, then the added
No,
will come.
sometimes children take the better of the parents.
Then it is a wrong path. And for safeguarding the children, so long parents are there,
That
they
you're
should
right.
learn the lesson.
That you're
That
absolutely.
your lordships will appreciate.
Absolutely.
Parents' experience and parents' lesson is the best lesson in the
Goes
world.
without saying.
Mr. Dhar, you are here only for because of our. No, don't. You.
Mr. Bandyopadhyay said this on a very light note.
No,
you're not.
light-
You're getting into the matter. You
You
must take it in the
Why
light
you have
note.
failed to achieve the order from the Supreme Court? Why you are blaming us? Why you are blaming us? You have repeatedly gone to Supreme Court. You couldn't fail.
Let's stop it here.
Don't give lecture now.
Yes. Why haven't you filed it, Mr. Bose? Everybody had the liberty to.
Well, with your lordship's leave, can I go, Milad?
Yes.
Can I go?
Yes.
At least Mr. Dhar will be happy. I can go.
No, I think deep down he won't be happy. What? Why haven't you? Today was the date. No, leading light of the bar was there, and so you could not address. But the light from this end, was audible and visible to everybody that you have to file the note by today. You're not deaf and dumb. You should have filed it today. Closed. So far as you're concerned, closed.
I am filing one over 12 and 14. Notes of argument.
special order.
Filing
today.
Just whichever matters, Mr. Sharnal, Mr. Bose, just indicate.
Give us little extension for filing the written notes. One matter.
No, just indicate in your note For who you're filing and in which item number?
The item number. And for the
By when, Mr. Shanal?
by a week we will do it.
I will not place the matter in the list anymore. You just give it to my court officers, it will be taken on record.
It did two things, my lord. One is that, my lord, all judgment, my lord, in 3-volume judgment, it is filed in the Bhim Sarkar matter. Although the
Item number?
Bhim Sarkar today's list, my lord, item number 5.
Very well.
Volume judgment was
Very
there,
well.
my lord. So, my lord, kindly kept it on Lubana matter because Lubana become the lead
ঠিক আছে, তাহলে লুবানার সঙ্গে ওগুলো রেখে দিই।
So,
First
Bhim Sarkar
matter সঙ্গে।
three judgment compilation
Very
was there.
Very well. Let us take 3 days, Mr. Dashgupta. If we don't complete, don't worry. I'm not going to rush anybody. You'll eat into my time anyway, from what I can understand. So, Ashun.
Number 19, 20 and 21 are strict matters.
Yes.
But I'll be praying for one date. I'll be praying for certain interim orders.
Yes.
Place these matters in new motion and thereafter, my lord, I'll
19?
19, 20 and 20.
Mr. Lahiri, let affidavits be filed. Your CBI, I will not give it now. I'm telling you. At the ad interim stage, I will not direct CBI unless I'm satisfied, prima facie at least. Tell me when. No, because till before the 4th, they will not be able to come because of their difficulties. So, Mr. Bond, where is Miss Promiti Banerjee? Mr. Singh, where? Yes, Mr. Bandopadhyay had difficulty on 11th and?
Mondays and Fridays, Your Lordship.
On Mondays and Fridays. Very well, 12th of May. 12th May. তাহলে 19, 20, 21 টা 12th May new motion এ থাকবে। হ্যাঁ? Mr. Mujumdar, you are appearing for whom? You ঢুকে পড়েছে।
My lords, I beg to appear.
Yes, just a minute, sir.
12 and 14 we have given.
Hey, appear, Dash Babu. Correct.
Then see the last order. in law.
Yes, they're here. Universities, you're not for the university. Who is for the university? Served. Yes, we'll take up the matter. Doesn't matter. Yes, tell me. Yes. Yes. Yes, I've seen. Yes.
They issued a correction by which they have modified the earlier notification and said, no, it's not a permanent, it will be another ad hoc appointment. That I objected.
You are saying if it's ad hoc, I might as well
Yes, ad
continue.
hoc cannot be replaced by an ad hoc appointment. But that has been decided by the Supreme Court. I have already said.
In
Division judgment of the Honorable Supreme Court has said that an ad hoc appointment cannot be replaced by adding an ad hoc appointment. Is that right? Yes, sir. Judgment.
yes, show me the advertisement and the corrigendum.
Advertisement আর corrigendum কোথায় কোথায় কোন কোন হ্যাঁ পেজ নাম্বার দাও তুমি আর ওইগুলোকে দিচ্ছ
Yes, Mr. Bari, show me the.
P11 is at Malat page. It is P11.
P11.
Yes, Malat. Page 86, Malat.
Yes.
Original advertisement, it was so flat. Oh, corrigendum টা কোথায়? Where is the corrigendum? যেখানে ওহো যেখানে পরিষ্কার বলে যে না অ্যাডহক পার্মানেন্ট না আমরা অ্যাডহক অ্যাপয়েন্টমেন্ট করব। Where is that?
No, this is not the notification. Place it. What, Mr. Bari? Where is the notice for appointment of the permanent post? You said there's first a notification. You're not ready at all, Mr. Bari. The notice, the corrigendum. Show me these two. Come back. খুশি রেখে পরের সপ্তাহে রাখো। Yes, 24. Yes, so start the matter.
My lords, I'm appearing in item number 24 and 25. My lords, this is regarding a question asked in the subject of biology in SLST 2, my lords.
Yes.
My lords, the first, the item number 24 is regarding the petitioners who have been called for verification And the item number 24 is for the group of petitioners who have not been called for verification. They couldn't make it due to 1 mark, my lords.
24 is for petitioners who have been called.
Yes, my lords. And they're
And
in
the-
waiting list. And the second petition, item number 25 is for those who couldn't make it due to
Paid.
1 mark, my lords. And the question asked.
Fees paid. Entire court fees paid. Yes.
Yes, my lords. My lords, may kindly allow me to submit a supplementary affidavit because my colleague couldn't attach few documents that are very important, my lords. My lords, may kindly allow us.
If on the first day, if you ask for a supplementary affidavit, it's very difficult. No?
My lords, I'm really sorry, my lords. I apologize for that, my lords.
Have you served supplementary? Supplementary, the
24. 24 and 25 actually.
Yes.
Yes, my lords, the question asked is in page 66 in item number 24. Page 66, my lords.
Yes.
Well, as the question asked was the second order neuron in the optic pathway.
Question number.
Question number 1, my lords, in item number, in page number 66. Question number
Yes.
1.
Yes.
It is a biology subject, and the question asked was the second order neuron in the optic pathway.
Yes.
My lords, in my supplementary affidavit, I have submitted 2 documents. In the model answer key, my lords, that is in page number 6 of my supplementary affidavit, my lords.
Yes.
My lords, it will be serial number 33.
33.
Yes, my lords, serial number 33 of page number 6 in my supplementary affidavit.
Yes.
My lords, the answer key is B.
No, why is it serial number 33?
My lords, page number 5. My lords, may kindly see page number 5. It is. My lords, may kindly see master key number 33. The question asked in set A is question number 1. The
Yes.
question number of question in set number A is number 1. In
Yes.
set B, the question is number 24. In set C, the number is 45. This is the same question, my lords. The number has been changed in all the sets.
Yes.
So in page number 6, my lords, the master key number 33, the answer is given as B. This is model answer. This is not the final answer key, my lords. This is the model answer key.
Yes.
Preliminary answer key. And when the final answer key was announced, my lords, that is in my page number 7, biology science.
Yes.
And the my lords, may kindly see item serial master key number 33. The answer has been changed to C.
Where do I find 33 in page 7?
8, mate. It starts from page 7. It goes at page 8. Master key number 33. The answer is C.
Where do I find 33?
My lords, in the second column.
Yes.
Second column 33.
Yes.
The answer is now changed to C.
Yes.
And my lords, I have not given any opportunity to raise any objection, my lords.
No. I have passed several orders on this. You see, when the chance for giving an objection is only at one instance, once the preliminary answer key is published.
My lords.
And then there's an expert committee who decides, and then the preliminary answer, there's a final answer key. Once the final answer key is published, there is no way you can challenge it. I quite appreciate your anxiety that you don't get, if you're in the preliminary answer key or answer is correct, and if it is changed subsequently, you don't get an opportunity of challenging it.
My lords, but both the answers are right, my lords.
I've already passed an order on this.
Malas, but both the answers are right. It is right that the ganglion, that the bipolar cells are the second order neuron.
Hasn't been uploaded. Well, kalke order upload hoyni keন?
WPA number 5112.
Uploaded. Check.
We checked it yesterday.
Once
Malas,
the
we have submitted several representations as well. They could have reverted us back that you cannot raise any objection regarding.
rule 11, sub rule 4 and 6 are very clear.
Okay,
The only chance to object is once the preliminary answer key is out. Once the final answer key, they have already decided that on the 14th of October, and then the results came out. So if you've not challenged it,
But Malas, what if the answer is not correct?
I agree with you. I agree, but then you have to challenge the rules, no? Unless the
My
rules
lords,
aren't a challenge.
my lords. Absolutely correct, my lords.
As a writ court, you know, my hands are
Absolutely correct, my lords.
rather
Absolutely
limited.
correct. My lords, may kindly then give me a liberty so that I can so that I'm not hit by res judicata, that I have already filed it, so that I
Not
can.
required. Not required. Your liberty is not required. You have that liberty anyway.
Very well, my lords. Very well.
Or Mr. Singh, possible to consider the representation made.
The petitioner, my lord, is of 11-12 category, my lord. Now, my lord, counseling and appointments are going on.
Yes.
Consider representation, my lord. I will be sitting in appeal over my expert committee, who has already decided this issue. And then I'll be violating rule 11.6 provision, which has been fallen from your lordship.
Are show me that order na. Order ta dekhao na. WPA server code. Mr. Singh, tell me the WPA number.
Uploaded 5112.
Yes. Tell me the WPA. We'll take out a copy.
5112. Dilam ekbar. हाँ. A total of 461 persons objected to these questions, pursuant to which this review was
after the preliminary answer key.
The preliminary answer key, and experts found that the preliminary answer key was wrong, and hence it was changed.
No. The preliminary answer key is not wrong, my lords.
She is saying both answers are possible.
Yes.
So what happens in that case?
My lord, experts report is that answer A is correct and option C is not correct.
No, my lords, that is not correct. I can submit.
Madam, I sitting in the writ court, I can't decide that over the.
My lords.
Wow.
26.
When did you make the representation, madam?
My lords, I started making representations from 9th of November, my lords. Until 23rd of February, I kept making representations. My representation starts at page 135 of item number 24, my lords.
Very well.
P6.
And item 24 is a successful candidate, right?
Yes, my lords. Yes, my lords.
Very well. একটা লাইন ঢুকিয়ে দেবে প্যারাগ্রাফ 10 এ 10 and 11 এর মাঝখানে একটা প্যারাগ্রাফ ঢুকিয়ে দেবে the petitioner being a successful candidate is entitled to be considered for interview and at the counseling stage, subject to availability of seat, considered by the for the interview and the counseling stage for onward allotment. Stop. Yes. 25 এর এটা ঢুকবে না, এটা 24 এ 25, madam, the representations are of the same date.
No,
Item
my lords.
25,
No, my lords.
write a copy the.
My lords, may kindly give me a second.
Yes.
My representations are P6, both are same.
Huh?
It starts at P6 110, page number 110.
The
My lords,
pencil.
it starts from 8th November.
Very well.
My lords, at least for the, they may consider us, my lords, for the representation at least.
The problem, madam, is they are saying if they consider your representation, that will tantamount to them sitting in appeal over the expert committee's decision.
I understand that, my lords, because
So-
I'm saying this because we need a sympathetic view towards these people who have already lost their jobs without any fault, my lords.
Well, really can't be helped. I mean, they have, but 25 is unsuccessful.
Yes, my lords. 25 is unsuccessful, and I have annexed few papers, my lords, that
So there
shows bipolar is the right answer.
The এখানে 10 and 11 এর মাঝখানে 25 এ ঢোকাবে, the petitioner is an unsuccessful candidate and is an unsuccessful in fact একদম উপরে দিয়ে দিও, সেকেন্ড প্যারাগ্রাফে দিয়ে দিও এটা, এই একটা লাইন 1 and 2 এর মাঝখানে 25 এ ঢুকে যাবে. Yes, sorry madam, both writ petitions will have to fail.
My lords, may kindly give me at least the liberty so that I
Not
can.
required.
Not required. Very well, my lords. Very well. Very
Yes.
well, my lords. Very obliged. Very obliged.
Yes. Yes. Yes, 26. এই অনির্বাণ একটা লাইন দুটোতেই ঢুকিয়ে দেবেন that the petitioners have chosen not to approach this court when their representations were not considered in November and waited for the publication of the results in November 2025 and have filed these writ petitions at a rather belated stage.
My lords, I kindly request, my lords. They were waiting for the answers of the commission, my lords.
That answers were out in October.
They were actually waiting for the answer from the commission, my lords, because I have appended some pages that actually shows they have given the right answer, my lords.
Yes.
Delay may not be, my lords.
It becomes a ground. 6 months, you've approached the court. After 6 months, you've waited. Your clients have waited for the.
My lords, we filed the writ petition before as well, but due to huge.
Thank you, madam. Yes, Mr. Chairman.
I am led by Mr. Pradeep Kumar, appearing for the state.
But I have to take your losses to some of the pages of my appointment letters and recommendations. Lord, your losses kindly come to page 32.
What is the matter about? First, tell me what is the matter.
The petitioner in 12th RLST. First RLST in 2016, 12 was selected and recommended and appointed. He joined. Malad in 2013, December. He worked for a few days. Thereafter, he didn't go to the school. Now, Malad in 2016, he was again selected. He was recommended. He joined. Now, as per the judgment of the Honorable Supreme Court, he lost the job. Now, paragraph 47 of the Supreme Court judgment says, whosoever earlier appointed, they should be allowed to go back to their earlier post. Now, accordingly, he pointed it out to the commission. The commission again. The commission again recommended her to the him to the earlier post, and appointment letter issued, joined, appointment approved. He used to draw salary. Now, all on a sudden, that has been withdrawn with the grounds that in earlier service, you only did for few days, and thereafter you were unwilling to join this, and therefore your service is terminated. Now, your losses, the impugned order.
Yes.
Your losses will be getting at page 46. May I just tell your lordship?
Yes.
With reference to the above, it is stated that Sushanto Kumar Deo has joined as per assistant teacher as an assistant teacher in this English education subject on 24th November 2025 on reinstatement in Banarhat Balika Parma Hindi High School via the recommendation letter dated 1st 11/2025 and appointment memo dated such and such. However, history of his previous service is given below. Regarding his first school named Banarhat Balka Porimal High School, date of joining 20th December 2013. However, incumbent worked for only 2 days, that is 20th December 2013 and 21st December 2013, and left the school without any resignation letter. No employee ID was created for payment of salary. He also submitted his unwillingness for joining to the post to the chairman secretary on 30th December 2020. This is not according to me correct. The matter was not informed to this office by the authority at the material point of time. Regarding his second school, name of the school, Noihati Anand Sarup, such and such, date of joining 20th September 2018, that is Malak SLST first, 2016 appointment. District approval to the 26th November 20, date of release 22nd November 25. On verification of record, it is evident that there is a gap of 4 years, 9 months in between his unwillingness letter to join in service and date of joining of his second service. I am seeking a valuable instruction regarding issuance of approval in his favor for reinstatement. This is my.
Your first joining was RLST.
RLST.
4 years and whatever from RLST, SLST. SLST in 2025 you lost. Or prior to?
Prior to your Supreme Court judgment.
2025, April 2025. You lost then. So prior to Supreme Court, they never raised a question on your years of service. Yes.
Now, the point remains, I did not further went to that school. Earlier.
First school.
First. That do not amount to resignation. There is no disciplinary proceedings, nothing. Appointment letter was there, approval there, Malad joining is there. Now, Malad, if there is no resignation, I am entitled to go back according to the Supreme Court para 47 to mine, and that was allowed by the commission. And without giving Malad, that was now being disapproved. That's the point. But it's the fiction.
No, you are allowed to go back to the school where you were serving, not to the first school.
First school?
No.
Yes, sir.
First school.
First school. That was given your lordships. Can you have a look at your lordship page 42? The Supreme Court judgment. This is the recommendation letter of the commission.
Page 42 of what?
42 annexure P13.
Oh, I see.
Then I will take your lordship the paragraph of the Supreme Court judgment.
Yes. Yes.
So this is a recommendation letter dated 1st November 2025. Kindly see the name in the column. Sushanto Kumar Deo and the school Banarhat Balka Porimal High School. That was the first school of 2013. And then your lordships, the appointment letter by the board at page 43. And then your lordships, I joined your lordship page 44. And then your lordships, the certificate that I was working in the school. And then the Malad, the impugned page 46.
Yes.
Only one thing I must point out to your lordships, they are saying unwillingness. That letter, your lordship, I must place before your lordships. That's at page. Malad, kindly Malad, the first appointment letter at page 32 in 2013. Let's just have a glance, your lordships. And
Yes.
then your lordships, page 33 appointment letter.
Yes.
32 recommendation. Page 33 appointment. Page 34 joining. This was allowed to join. I worked according to them 2 days, according to me 7 or 8 days.
Yes.
And then you also what they are banking upon page 35.
Yes.
I am unable to join for the post for some family related problems. They say you expressed your unwillingness. That's not a resignation, Mala.
Yes, provided depending on how the school has treated your
my
somebody
submission would be
if after you somebody else has been appointed to that post,
then I could not have been allowed. That I could not have been allowed 25.
So it's still a vacant post.
That's the gossips. Now the
Yes,
point
it is for the
is,
school.
sir, unless I am treated as resigned or I
Yes, I've understood.
Master servant
This is
relation.
for the school. Commission has given its recommendation. Then
I've joined.
Then
you also say letter, disapproval letter. Page
46. No. So yes.
My appointment is disapproved.
By the DI?
By the Commissioner of School Education.
Commissioner of School Education.
No.
47.
47.
Kindly
47.
47.
So commission has
Yes, my lord, I am for the state, my lord.
Commission has disapproved. You're for the state. You're for the commission.
Yes.
So commission has disapproved.
Disapproved, my lord. Kindly take trouble to come at page 35, my lord. But the subject, kindly see, my lord.
Yes.
It is on the first date of joining, my lord.
Yes.
First, the subject is unwilling to join the post of assistant teacher.
Unwilling. He says I'm unable. Inability.
Unwilling, my lord.
Where?
Subject, my lord. The fourth line.
Subject.
Yes, my lord. Unwilling, my lord.
Context.
Unwilling to join the post of assistant teacher due to some family related problems, my lord. It is on the first date, my lord, 30th December. Oh, sorry. No, my lord, he was joined in 20th December. 20th and in the page number 46, my lord. On the DI has recommended the matter to the commissioner.
Correct.
That is, my lord, on this. On the middle portion, my lord, date of
joined on 24th November. He, according to the DI, he attended for 2 days, 20th and 21st.
Yes, ma'am.
Date of joining is 20th of December. For 2 days he attended.
Yes.
Thereafter, he gave this letter of unwillingness.
Unwillingness and left the school without any resignation letter. And no employee ID was also created for payment of salary. He also submitted his unwillingness on 30th December. Ma'am.
Yes.
The matter was not.
His previous service was not approved by DI. Whenever a person in service was joining, 2 years provisional joining.
Right. Right.
Thereafter, unwilling.
So not approved.
Not approved.
I got 2020. And at that point of time.
So if there's still a vacancy there or not is something we'll have to ascertain.
But in this picture, what the commissioner's has stated here, but that picture was not neither before the commission, neither before the board. Why? Because 2030, managing committee was the funding committee, and managing committee was the but a person who have only worked for 2 days, thereafter not joined, and was not approved. So, he is not in service. Until and unless person's service is approved, 2 years service provisional, thereafter approved by DI.
Approval has to be after 2 years of joining and serving. So he joined for 2 days.
2 days.
Service. Now my lord,
So
of Supreme Court.
no, show me that portion of the Supreme Court order. I'm a little
47.
Para 47.
Paragraph 47.
Yes, place it.
Nail it down.
Yes.
Some of the appointed candidates who do not fall in the category of 10 candidates may have previously worked in different departments of the state government or with autonomous bodies, etc. In such cases, although their appointments are cancelled, these candidates will have to right to apply to the previous departments or autonomous bodies to continue in service with those entities. These applications must be processed by the respective.
Yes. So, Mr. Shanal, the logic here is you are working at, let's say, place X. Because of 2016 SLST and you were successful, you got it in Y. By this order, your service in Y is terminated. So, Supreme Court says, we don't want to prejudice you. You go back to X. You'll have the liberty to apply to X. Their point is, you are not actually working in X. That's the issue.
Actually work. I tell you, as soon as the recommendation letter issued, appointment was issued, I joined, worked for 2 days or 7 days according to material. I submitted, I am unable to join with the subject unable. There is no action taken on the basis of that. My master servant relationship according to service jurisprudence still remains.
No.
Kind your losses consider. Master servant relationship is, that's one thing, 4 years. Kindly allow me to develop it. Kindly allow me to develop it. This is according to service jurisprudence. That
service jurisprudence will come later. First, you are not even in the employee relationship without that approval of 2 years.
That's not the point. Your approval is equal to service yet to be given. They have not yet said that your service is.
No, what were you doing for the 4 years and not?
Some family problems were
for
there.
4 years.
And
then after SLST, your family problem disappeared. No. Not very happy with the conduct.
Conduct in a sense, but I also didn't get the salary. It's not
actually.
No.
Not
that is not a fact.
What is not a fact?
That's I got the salary without.
Nobody is saying you got the salary.
So this is the service relationship, master servant relationship remains.
No.
Kindly consider that your lawsuits. Maybe one of the ugly facts that I didn't work for.
That's the only fact, and it's rather ugly.
But your lawsuits remains. Service relationship remains.
No.
That's my point. Your lawsuits. Otherwise, I will.
If there's a vacancy, can you accommodate him? Your commission has withdrawn. Commission has withdrawn the recommendation.
Yes.
So can the commission? No.
Joining has completed, but
page 47.
The conduct has been shown.
Page 47.
47.
47.
Yes, ma'am.
No. May you won't help, Mr. Bhattacharya. Please clarify my doubt. Page 47. The commission is withdrawing its recommendation. What may I? Yes.
Commissioner of School Education.
Is a separate body. Yes.
Well, commissioner is the state.
So why did the School Service Commission recommend? File a report saying that you did not know, and the commission had given the recommendation without knowing this fact. You file that report. Why haven't you withdrawn the recommendation? Why haven't you? That's exactly what I'm asking, Ms. Banerjee. Why haven't you withdrawn the recommendation?
According to me, verification was done as per Supreme Court judgment. Then recommendation letter was issued. And I am today without service.
That is his only defense. Why are you submitting on behalf of the commission?
Unless
you are the board. You've issued the appointment letter on the basis of the commission's recommendation. So let them deal with their problem. You deal with yours. Then why did you give this? Without ascertaining, Ms. Banerjee, you file a report. How soon can you file the report? Ashur, the commission, now the petitioner has agreed that the petitioner's service has not been No, you're serving, Mr. Shanal. You've joined, but you're not getting served.
I had joined, I was working, but no salary has
No,
yet.
sir. You're still working.
Still working.
The petitioner's grievance is that the petitioner has been working in the erstwhile in the school school time. What is the name of the school?
I just give you a notice. Banarhat Balka Porimal High School.
Banarhat Balka Porimal High School. Since December 2025, however, without any remuneration. Stop. The petitioner was a successful candidate in the first SLST examination in 2016 and had been appointed to Noihati Anando Sharup High School in September 2018. Stop. The service of the petitioner has been affected by the entire process of the first SLST being discarded. Stop. The petitioner has thereafter, on the recommendation of the commission, joined the erstwhile school. Stop. The reason for non-payment of the petitioner's salary and other benefits is that the petitioner had never joined the school in essence, as he had rendered only 2 days service and thereafter by a letter of unwillingness never served the school. Stop. Next, in the circumstances, it is strange that the commission had rendered its commission had given its recommendation in December 2025 without considering these aforestated facts. Stop. The commission will file a report by April 10th, 2026. Stop. List this matter under the same heading on April 13, 2026 for further consideration. Opore affidavit of service as filed be kept on record. Yes. এটা আমাদের থাক ওটা আছে এখানে হ্যাঁ আছে এটা দিয়ে দাও ফেরত দিয়ে দাও Untented. Only issue, Mr. Bandyopadhyay, is Mr. Shanal's clients are not being paid. He's joined. He's working, but he's not being paid his salary on the ground that he had initially joined only for 2 days and thereafter is
Now, thereafter 2016 he has been selected.
18. Yes, 16 selected. After the Supreme Court order, he went back. He's allowed to join. Salary not being paid because
No, I have to check up. I will let.
that's why I let the commission file a report.
Put and we'll see.
Yes.
The only issue is the salary.
Only issue is the salary. Where's Mr. Shanal gone? Gumpeta Aditya chole geche. Yes, you're there in the next matter.
No, we only issue is.
We'll have some excitement then.
No.
I'll have some excitement.
Oh, achha. I understand. Oh, I always feel pleasure to see him in the corridor.
Only in the corridor?
Yes, looking for is a great pleasure. In court, he is dangerous. But in the corridor, he is very amenable person. Excellent. Right from Rabindranath to Jyoti Bosu.
Everything. No. Right from Rabindranath to Kollal Bosu.
Kollal Bosu. No, he says only Chief Bosu is there. And who can become a chief minister?
One is gone.
was Jyoti Bosu.
Then I'm missing the second one. Third to I know.
Subhash Bosu was first. Then the Jyoti Bosu.
Oh,
and then the Kollal Bosu. And Justice Dipankar Datta said Sore Bosu.
Yes.
But it is really nice to talk with him
Very good. He's very knowledgeable.
outside. And he is very dangerous in court. No, but he is very pleasant. And all the
that he
time
is.
I get chance, I just catch on. Speak about Jyoti Basu. So many incidents he knows about Jyoti Babu. Unbelievable.
He knows many incidents about many people, not just Jyoti Babu.
That I do not know what his speech about Jyoti was. But we know what his son has said.
Yes, yes.
I am telling you. That time UPR was going on.
এটা অফ আছে তো?
বন্ধ করতে তো।
অফ আছে তো?
অফ করো, অফ করো। এটা
কিছু ব্যক্তিগত কথা তো আপনি
অফ করেছি তো। One day I was coming from and this gentleman, who is the chief
I'm an associate professor of Indian Statistical Institute. Now, my lord, in this matter, my lord, my client has, my lord, questioned, my lord, the propriety of a complaint letter,
Yes.
appointment of an alternative, my lord, disciplinary authority, show cause, charge sheet and inquiry, my lord, proceeding. My lord, 13/10/2025, annexure P3, my lord.
Just tell me the facts, Mr.
The fact.
Vasu, then we'll get.
My lord, 7th October, my lord, there was a meeting, my lord, wherein, my lord,
Concise the facts.
Yes, yes.
Don't go into
My lord,
date. Just tell me what has happened.
I am an associate professor,
Yes.
my lord. I am an associate.
This is the problem. You maintain a light atmosphere in court, everybody takes it very lightly.
It's a matter of pedigree and understanding environment. Your lordship is not responsible for everyone's. In Bengali, there is a
No,
famous...
for my court, I am responsible.
Yes, yes, no. Because, my lord, Amar pore nahi bhubaner bhar. Your lordship has not my lord, nurtured them, not a teacher, not a parents.
Doesn't matter. In my court, I'll.
No, but throw them out. Your lordship is gentle but not weak. Your lordship.
Sometimes I can be not so gentle also. Yes, tell me.
I'm an associate professor, my lord. There was an interaction between the professor and the chairman of the ISI, my lord, the Indian Statistical Institute, my lord, wherein, my lord, I have questioned, my lord, the propriety of the extension of a director, my lord, which is beyond law and rules and regulations and the statute. My lord, such meeting was held on, my lord, 7th October 2025. 13th October.
Challenging the extension of tenure of the director.
I said, my lord, that was a yes.
This is what you are challenging.
Yes, my lord. No, that is in a different matter. That is by others. I have sent an email to the chairman. Thereafter, a meeting was held.
Then,
in that meeting, my lord, according to my lord, the deputy director, my lord, that the director, who is a lady, my lord, she was, my lord, confronted with certain languages which are not palatable and, my lord, against the norms of the established norms of our society, and which also is an onslaught, my lord, to the values of our system. Now, be that as it may, my lord, deputy director was very much, my lord, annoyed with such expression of mine, because the director of the institute, a lady, that is, my lord, that was an insult to her. He lodged a complaint with the
deputy director lodged a complaint against you.
Against me.
For unparliamentary language used against the director.
Yeah, director, my lord. But, my lord, I was not, my lord, favored with any complaint or any expression of agony and affliction or insult, my lord, meted out to the director, the lady. Be that as it may, my lord, the show cause notice was issued. Show cause, I said initially, my lord, that what is the nature of the complaint? Number one, give it to me. Number two, my lord, there was no morsel proof showing, my lord, there was a preliminary inquiry. My lord, be that as it may, my lord, they, my lord, sought to appoint a disciplinary authority, which I said, my lord, under the rule, my lord, who should be, my lord, a disciplinary authority of a person for an alleged misconduct. My lord, I said also, my lord, after the show.
Are you asking for an interim order?
Yes, my lord, I said, my lord, the inquiry should not be proceeded with, because, my lord, that is my lord, I tell your lordship, the normal standard of the Supreme Court that the correctness of the charge sheet, the inquiry proceeding, I must face. That is the law, my lord, of the land. But that is not a rigid one, because, my lord, that is, there are exceptions. Because I tell your lordship, the first of all, if any executive action.
No, but that's not an interim order.
No, interim order means, yes, interim order here, my lord, since I have said at the outset, complaint letter, appointment of alternative disciplinary authority, show cause, charge sheet, and inquiry proceeding. When it is a question of jurisdiction, my lord, your lordship has taught us, my lord, it goes to the root of the matter. My lord, this is a lordship means, my lord, chair. This is your lordship is a constitutional.
I haven't said anything.
No, my lord, the expression, my lord, it causes embarrassment, pleasantly embarrassed. My lord, I tell you, lordship, my lord, that this is obviously not a news to the learned counsel appearing for the respondent, my lord, that when it is a question of jurisdiction, the Reed Court, my lord, can always enter into that question if I can satisfy my lord judicial conscience, number one. And number two, my lord, if it is a judicial review court under Article 226, and it is, my lord, then, my lord, the right to, my lord, ask for a judicial review of an administrative action is, my lord, under the basic structure doctrine and the fundamental rights. If that is so, my lord, that is, my lord.
What is on the maintainability?
No, maintainability, no. Maintainability comes, my lord, it is intertwined, my lord, interlinked with the, my lord, the premise of a prayer. If I say that your initiation of a disciplinary proceeding, appointment of an alternative disciplinary authority, show cause, if it does not, my lord, prima facie, my lord, show that there is well within the power, and any conversation.
Are you saying that it's not within the power?
I say, my lord, that is not within their jurisdiction to issue, my lord, an appointment to an alternative disciplinary authority. Rule does not say so. Why? Because yes, my lord, first of all, my lord, your lordship wants me to show first show cause or, my lord, everything. No rule.
Howsoever you wish to proceed.
Yes, I'm extremely grateful.
Abridge it.
I'm extremely grateful.
Unnecessary sermons, conjectures not called for. Show me the documents and let's get on.
Habit is a second nature, kindly excuse me. Name. 127. First, my lord, I will show, my lord, the alternative of a disciplinary authority is an appointment.
Yes.
May I take my lord's kind attention, my lord?
Yes.
A complaint has been received against, that is my client, my lord, associate professor, such and such, machine intelligence unit, for aggressive behavior and use of derogatory language against professor such and such, officiating director ISI, during an undesirable incident which occurred on 7th October in the conference room of the director's office at ISI, Kolkata. The complaint was lodged with the officiating director ISI, which was forwarded by her to the chairman of the ISI council through an email dated 18/10/25. The officiating director in her email had intimated that she would like to recuse herself from handling the complaint as the disciplinary authority since the reported incident involves her. In view of the seriousness of the matter and in consideration to the severity of the alleged misconduct, the chairman has decided to appoint an alternative disciplinary authority to initiate disciplinary proceedings against such and such. Since Professor such and such officiating director is involved in the reported incident and therefore, in order to uphold natural justice, has recused herself from acting as the usual DA, the chairman of the ISI council, being the next higher authority in the organizational hierarchy, has decided to appoint the following official as the disciplinary authority for the present case only, such and such. The chairman will continue to act as an appellate authority in this matter in case any such need arises in future. This issues with the approval of the chairman, council of the ISI. Next. Millet rule.
Yes.
Standing service order, it starts from page 66. It's relevant page. It starts from 59, Miller.
Yes.
I take my lord's kind attention to page 66. Rule 10, Miller. Subject to provisions, may I read for my lord? Rule 10.1. Subject to provisions of this order and other rules, regulations, orders, etc., which may be in force, the following categories of penalties can be awarded to a worker for good and sufficient reasons: warning, censure, withholding of increment, stoppage and promotion for a specified period or indefinitely, reduction to a lower stage in a time scale, reduction to a lower time scale, or ad hoc pay, removal from service, compulsory retirement, dismissal from service. Then 10.2. Reversion of a worker, in Appendix 2 are indicated the authority is competent to deal with disciplinary matters. In any case not covered by Appendix 2, a joint director or a joint secretary would be competent to take action. In any proceeding, that is not relevant, kindly comes to Appendix 2, page 97. May I take my lord's kind attention to page 97. For Millard, this is Millard disciplinary and appellate authorities. Page 97. I'm sorry, Millard. Page 97.
Yes.
Now, Millard, it indicates Millard disciplinary and appellate authorities. Why I'm taking to Millard's kind attention to this, Millard? It speaks about, Millard, that the employee classes of workers. I am falling under category 4, last paragraph, consolidated above rupees 800 and time scale starting from above rupees 750. At that point of time, this is Millard. This was issued, Millard, in 1960 or later, Millard. That is, Millard, immediate superior but not below the rank of a joint director. My lord's got it. My lord got it. Immediate superior but not below the rank of a joint director. Appeal regarding Millard, penalties rupees such and such. 10.1a and 10.1b. 10.1a, Millard, page 66.
Yes, you just showed.
Yes, that shows. That is a warning and sanction, and not others. Other penalties, Millard, director is Millard. Since the allegation, Millard, the complaint allegedly Millard written by the director is not there. So this is my lord, apart from director, the other persons, my lord, who is superior to me.
Yes.
My superior to me means my head of the department, machine intelligence, that is there, and head of my division also. Now, my lord, on this score, my first limb of submission with humility is that my lord, that this appointment, disciplinary authority is the appointment which I have read for my lord. That is, my lord, prima facie, it shows that they have lack of authority and jurisdiction. Now, my lord, 11.121, page 67.
Yes.
I'm sorry for being delayed, my lord. It says 11.2, the grounds on which it is proposed to take action shall be reduced to the form of definite charge or charges, which shall be communicated to the worker. A brief note should accompany the charge sheet explaining the facts on which the charge or charges are based to enable the worker to give an adequate explanation in his defense. 11.2.1, proceedings of any of the punishments referred to in clause 10.1 can be initiated in respect of a worker by any worker under whose direction and control the first mentioned worker works. The authority for issuing charge sheet shall be as indicated in appendix 2 of these orders, which I have read for my lords. Unless the authority mentioned in appendix 2 himself initiates the proceedings, the worker who initiates the proceedings shall submit his report with necessary facts, material, etc. to the officer mentioned. Now, my lord, kindly comes to 68. 11.5 and 11.6. 11.5. The findings of the inquiry under 11.4.1 without any recommendation for penalty, unless such recommendation is specifically asked for, shall be forwarded as early as possible to the authority concerned for issue of appropriate order. The authority concerned will have discretion to accept fully or in part to reject the findings and recommendations, if any, or to order a fresh inquiry into the charge or charges. Next, in case the authority dealing with the case considers that the punishment of dismissal or removal from service is necessary, he shall, if he is not the appointing authority of the worker concerned, forward the full record of the matter with his own recommendations to the appointing authority of the worker concerned for issue of necessary orders. The authority to whom the case may be so preferred shall have the full powers to accept in full or in part or to reject the findings and recommendations of the inquiring officer or the authority dealing with the case in the first instance. Then we learn 12.1a. 12.1, sorry. A worker on whom an order of penalty has been served shall have the right to file an appeal in writing to the appropriate appellate authority mentioned in Appendix 2 within a period of 30 days from the date in which he receives a copy of such order, provided that such appellate authority may entertain the appeal even after the period of 1 month at its discretion. Then, now, my lord, where is the decision that the alleged offense, which I have shown, my lord, 11.51, which is of such a nature, my lord, that for which a dismissal or removal from the service is necessary. So, at the initial stage, the authority has proceeded with a capsuled mind and, my lord, and with a contemplation, which obviously contains an element of bias, confirmation bias, hindsight bias, whatever it may be, my lord, the confirmation bias, that this is such a nature of allegation where it was necessary for the authority to appoint a disciplinary authority, alternative disciplinary authority, outside the ambit of the regulations, Appendix 2, 11.1, 12, and, my lord, 5.1, which I have shown to your lordships. Such, my lord, contour clearly demonstrates, my lord, that from the very beginning, such perception, which is frightfully narrow, it contains an element of bias and a prejudged mind that I have committed such a reverse offense, which has a not only has a disciplinary angle, but as an element of misconduct. So, my lord, there is, my lord, absolutely a malicious proceeding, my lord, under the guise of securing compliance of natural justice. It's a pseudo compliance. The moment the authority has proceeded, my lord, because why I tell your lordship, at the cost of tiring repetition, my lord, that if I can demonstrate prima facie that the exercise of power is outside the periphery of the regulations which they bound to comply, my lord, such element of, my lord, arbitrary exercise of power, my lord, goes, my lord, to the root and it hits, my lord, the point of jurisdiction. They are not permitted to do something which, my lord, law mandates.
Done,
Now, my lord,
understood.
2013
Anything more?
Now, my
Anything
lord,
more?
yes. Now, my lord, the language of the charge sheet, my lord, if it shows that there is an element of bias, the language is also important.
Show me the charge sheet.
Yes. Welcome. 145. May I read for a minute?
Yes.
145 তো এটাই তো চার্জ ভুল বলে ধরি A complaint dated 15/10/2025 was received
Are you
against
going to read the whole thing?
no Millet because then Millet from three
What do you want to place from here?
no Millet kindly see the paragraph
Show
2
me that part of the language which
yes
you think is
the first of the following incident reported to them
yes.
whether it has contained Millet any the incident occurred on 7th October during PICHD committee meeting on the draft ISI Bill 2025 held in conference room in which the complaint was also participated. While the meeting was in progress, a group of faculty and non-faculty members entered the director office shouting slogans and conveyed through an officer of the director's office that 5 members of the group wished to enter the meeting venue. As the meeting could not proceed amidst the slogan shouting, the officiating director was compelled to allow 5 persons to enter. Such and such, that is the petitioner for your lordship, Millet was one of the 5 employees who went inside the conference room. During the conference, Dr. Such and such, that is my client Millet, was one of the 5 employees who entered is an extremely aggressive manner and made some baseless statements. At one point, when the officiating director was about to leave the room, such and such, the word lapdog against her more than once. This conduct was unacceptable, highly derogatory, humiliating to the officiating director, which is also a woman. Now, Millet 149 articles of charge. Now, why I tell your lordship that the language is a trace of our thoughts, and it clearly says, Millet, the element of bias in no uncertain terms. During the reported incident on 7th October, may I read for my lord, while a meeting such and such on draft bill was in progress, the conference room of the director office, Dr. Such and such, behaved in an aggressive manner and used the highly derogatory and defamatory expression lapdog against Professor Such and such, the then officiating directors, ISI, maintaining politeness and propriety in interaction with colleagues during the performance of official duties constitutes the minimum standard of conduct expected of an employee. But Dr. Such and such, by his conduct, had clearly exceeded the limits of courteous workplace behavior expected during official proceeding. Dr. Such and such therefore failed to act in a courteous manner in the performance of his official duties and thereby violated rules such and such, which inter alia provides that no government servant shall act in government in a discourteous manner while discharging. I will show a judgment, Milord. This invocation of Rule 3 CCS rule does not apply to us. It do not apply. These rules do not apply because we have a standing service order which I have shown. Milord, I have a judgment of the High Court, Milord, of the division bench. I will show, Milord, the Allahabad High Court.
Place it, then you show.
And then, Milord, second, Milord, then they said, I used abusive and derogatory language against such and such, who was his superior authority in the presence of several other persons who were present in the conference room. By such conduct, I insulted, Milord, my client insulted Professor such and such and lowered her dignity during an official interaction. Such behavior was subversive of discipline and contrary to the rules. Then, Milord, kindly comes. That is, Milord, each employee expected. Then, Milord, the same thing, and this was issued. Milord, 17 witnesses, Milord, there are. Kindly turns, Milord, page 151. Your Lordship will be pleased to find that the director who was allegedly insulted and the deputy director who had lodged this complaint, my lord, on the basis whereof, my lord, this proceeding has been initiated, they were not included in the list of witnesses. And in my reply, I have also taken this point that why, my lord, if your lordship, my lord, permits me, my lord, that categorically, first of all, the disciplinary authority cannot be the persons outside the rules, my lord, those who have not been mentioned annexed to. Second, my lord, the language of the charge sheet while interacting, my lord, we represent a union, my lord, and that is the only union in the, my lord, ISI. My lord, an associate professor, my lord, while interacting, my lord, I sought for, my lord, the video recording and everything, my lord, the records of the proceeding on that date, my lord, whether who put their signatures, my lord, on the minutes, my lord, and what actually happened, and where is, my lord, the person concerned who was allegedly, my lord, that she was insulted, and, my lord, the entire exercise, because the charge sheet I have shown, my lord, that I clearly said they were definite that I have committed this conduct. So, my lord, first of all, without jurisdiction. Second, my lord, the language of the charge sheet. Third, my lord, the complaint, my lord, actually allegedly made, that was not supplied, but the deputy director's complaint was served upon me. And, my lord, if your lordship is with me, that basically the constitution of such committee and, my lord, the entire proceeding is absolutely standing on an erroneous footing and exercise of power, my lord, without jurisdiction, then, my lord, I possibly, my lord, need not proceed further. And, my lord, my reply, my lord, and the list of witnesses, my lord, neither the complainant and alleged complainant who was insulted allegedly, my lord, she was not the witness. And, my lord, who can be a disciplinary authority? The regulation says I head of the department or any person superior to me.
Show me.
No, 11.51 টা জজ সাহেবকে দেখালাম 97 না 97 না হ্যাঁ 67 টা না 67 68 68 67 না 68 60 proceeding 11.5 sorry Miller 11.2.1 proceedings Miller heading is 11 departmental proceeding. The following procedure should normally be followed in imposing any of the penalties enumerated in clause 10 above. No order. Then, Miller, 11.2.1 proceedings for any of the punishment referred to 10.1 can be initiated in respect of a worker by any worker under whose direction and control of the first mentioned worker works. The authority of charge sheet shall be issued in appendix 2 of these orders, unless and Miller, if they come to a conclusion that punishment is removal, then Miller 10.2, then disposal it will be, they will forward the report, Miller, to the appointing authority, who is a director. Since the director is Miller, the chairman is an appellate authority. Chairman said Miller in the show cause. Although Miller, the chairman is not the appellate authority, I would request Miller, Miller, according to me, Miller, the law says the council is the appellate authority because the highest body. Now, Miller, if my learned, esteemed friend, senior friend shows that chairman is the appellate authority specifically, Miller, I will show only 2 judgments. Miller, your lordship knows, but Miller, I said, Miller, that is reported in 2013 volume 2 CHN, page Miller 171, paragraph 12. May I read for my lord? And Miller, I will hand up to your lordship. Page 171.
2013?
Volume 2 CHN, page 171.
Yes.
May I submit one thing, Milord? 12:30 a fixed matter is fixed before the honorable division bench, Milord. Let him complete his argument, Milord. May I come back tomorrow?
আজকে একজন করে দিই তাহলে কি করব শুধুমাত্র এরকম
No, you finish it.
You finish it tomorrow.
Finish it.
Tomorrow, Milord, I will. 12:30.
না ঠিক জজ সাহেব অনুমতি দিলে আমাকে বলো 12 says I will hand it to you. So I'm sorry, I apologize, Milord.
We are on 2013 to CHN.
Page 171. It says, Milord. Paragraph 12, Milord. I'm sorry. It is a settled legal position of law that statutory body must act within the framework of the statute and cannot travel beyond the statute. One individual can do all things, save and except those which are prohibited under the law, whereas statutory body only can do anything as are prescribed within the jurisdictional parameters or control of the control statute, Reliance Millard, that is 40 CWN Millard, series of judgment 74. I will photostat copy Millard will be.
I don't want the series of judgments.
No, Millard, I only want. I am also Millard tired of Millard. I do not.
Yes, next.
Millard, if he comes tomorrow, Millard, I will show one judgment which is not readily available, Allahabad, which says, Millard, that the established.
You complete, Mr.
Not
Bose.
within Millard. That is
You give me the reference, I'll look it up.
মেলে আছে একটু বার করে দিন একটু মেলটা বার করুন আই এম সরি মিলাড গিভ মি মিলাড
Very well, day after. Ashun,
Sorry.
come back day after.
Yeah.
But just that one judgment, nothing more.
Not only two this yes.
This is not required. You give a copy. The other one, you bring a copy, you rely on that and finish off.
I'm sorry.
Please ask Mr. Tiwari day after, Thursday. Hear out the main petition only. We are hearing out the main petition, not
It's
the
a
interim
question of
order
law.
bit.
It's a
Not
question
not the interim order bit anymore.
No. If your lordship takes a final call, Miller.
Because otherwise, practically your submissions are on the entirety of the writ petition.
No, final relief. No, final relief is setting aside a charge sheet, and interim relief is restrain them from proceeding with the matter.
So if you fail in the interim relief, your final relief will automatically stand rejected.
No, Miller, yes,
They'll proceed.
They will proceed.
The petitioner has aggrieved. A premier institution is under threat, not from any outside agency or reason, but due to internal bickerings by two reputed academicians. Stop. Next, the petitioner has been subjected to an inquiry by an authority for initiation of disciplinary proceedings, for which charge sheet has also been issued. Stop. By way of this next, by way of the instant writ petition, the petitioner seeks to challenge first the constitution of the disciplinary authority, as the same has been done beyond the terms of the regulation. Now, what is this? First statute?
No, SSO.
Beyond the terms of the Standing Service Orders 1963 guiding the institute. And also, since the articles of charge reek of an apparent bias. Stop. The petitioners challenge that the proceedings should be stayed on the ground of jurisdictional error is presently being considered. Stop. The second limb of the petitioner's grievance, that the charge sheet is biased and ought to be stayed, will fail automatically in the event, will be decided automatically in the event the jurisdictional aspect is decided first. Stop. Next, Mr. Bose, learned senior advocate.
I'm not resident senior.
Oh, no,
I am.
Mr. Bose, learned advocate appearing for the petitioner, has raised 3 issues, which may be summarized as under : A, jurisdictional deficiency of the disciplinary authority to initiate and carry on the proceedings against the petitioner, thus making the entire disciplinary proceedings non-est, without jurisdiction. B, charge sheet leveled against the petitioner prima facie seems biased, as the authority making the charge sheet has already come to a conclusion regarding the petitioner's guilt. 3, the complaint made by the director,
Deputy Director and Director.
complaint made by the director was never handed over to the petitioner, though the complaint on the basis of which the proceedings were initiated, that of the deputy director, has been handed over to the petitioner. I'm not unmindful.
No, I'm sorry.
Stop. Next, on these aforestated grounds, the matter has been substantially heard. Stop. Mr. Basu prays for a day's time to come back with a judgment which he wishes to rely upon. Stop. Let this matter appear in the list on April 2nd, 2026 for further consideration. Stop. Under the same heading.
Deeply obliged, minute.
Yes.
I'm extremely grateful for your lordship's patience and
I
tolerance.
don't take notes, but I am not unmindful.
No, I'm sorry, minute.
I don't have as good a memory as Justice Ray, but still.
In the making. In the making.
Yes. Yes.
On it college.
Yes.
Affidavit service.
The outset, I might humbly submit that there is no scope for any
Interim order. Let me hear Mr. Banerjee. Let me see what his prayers are.
Lordship will find an advertisement was called for as on page 15, pursuant to which I was appointed in the college. Now, it was in 2013 I was appointed, and subsequent thereto, in fact, Lordship will find college has put forward my name to the government concerned in order to approving the same and in order to enhance the funds. Page 29 will reveal the same. Page 28, the names of the employees being indicated herein, and page 28, the names, Yama, and page 29, the very first line, resolved that the appointment of these incomes be approved from such and such a teacher in charge is requested to submit the claim of pay and proposal for the government approval of appointment.
Mr. Banerjee, first, what is your grievance? Let's understand.
The grievance is, I have been engaged in a college from 2030, and there has been memorandums from the government end as per enhancement of the pay scales. Now, there has been memorandum which has been adopted by the Higher Education Department, by the Finance Department. But you will find that from the same. And in fact, I am already covered by Lordship's own judgment to this effect that Lordship has already dictated in one of the matters, and similar matters has already been taken care of by the division bench also. Now, if your Lordship be with me for one moment.
That order has been challenged in appeal.
No, not Lordship's order.
Then?
One of the matter Lordship has dictated, and other two matters from the division bench from other courts. From other courts.
But other courts?
Issue is same.
No. Is the division bench still considering this issue?
Issue is same. Issue is same. One Lordship has decided.
Is the division bench still considering this issue?
No. Decided. And Lordship will find only one thing if Lordship kindly turn. Yes. From.
You still haven't told me what the grievance is.
Grievance, Lordship will find.
There are notifications since 2013 you've been in service. There have been enhancements by way of memoranda and notifications. And then what happened?
Not yet.
You've been deprived.
I've been deprived.
Similarly situated people are getting it.
Similar situation people are getting.
Yes.
Now, in fact, Lordship.
Ms. Mitra, you are appearing for?
I'm paying for the college. Lordship, this is a college which is.
Who is to pay? The college or the university?
They are being paid from the college's own fund. This is not a case that they are all getting a consolidated pay of 9,000 rupees per month.
Sometimes the board takes a resolution to even lessen the pay because the college funds do not permit. They
It's
only,
not an aided college.
it is an aided college, but these posts are not sanctioned posts.
Oh.
So these are all,
Posts and they are getting paid from the governing body of the college.
yes.
And they are not appointed against any sanction post or approved post at all. They can't take the benefits as
These has already been answered. These has already been, yes. Lordship, have a look. As your lordship's
This is not
judgeship.
a case for consideration even. I'll come to that. Let him finish his case.
But this was your lordship's judgment. And Judge, and this one is, yes. Huh.
That means whether the factual aspects in
And
this matter are same or not.
Mr. Banerjee, this is a completely different issue.
Issue is different in a sense that the posts are different. And they hear it. With the division bench, it is the same issue. দুটোই আছে। I knew this. Division. This is with regard to the 2011 memorandum, which has been reshuffled and enhancement has been scheduled.
9008 যেটা এর ক্ষেত্রে এই তোমার SAC teachers আর
No, these are in respect of casual daily contractual workers who have been attached to various establishments
yes,
for a period of not less than 10 years.
Yes, we are also 2013.
No, but they are saying you are not even sanctioned post.
This is their statement. Let us come. What was the post from the college itself? Can you have a look at the appointment letter? Appointment letter, Roshi, have a look at page 64.
Just a minute. When were you appointed, Mr. Banerjee?
2013.
Have you seen this the division bench that you handed over?
Yes, ma'am.
You are hit by it. It goes against you.
After all, Lordship will find there are all payments has been made, monetary benefits has been given.
Please, if I'm saying something, before saying no and yes, please consider what I'm saying. Come to paragraph 12 of that judgment of Ekteshwar Adhikari. Come to paragraph 12, read it.
Subsequent to the memorandum dating.
Yes.
I'm
We have a-
2013.
Yes. So from 2011, every appointment to a non-sanctioned post will be guided by it. You will be hit by it.
Herein also.
No,
20
here the appointment was of 1998. It will not have a retrospective effect, is what was held.
No, Lordship will kindly have a look.
Come to paragraph 5. His appointment is of 1998, which is why the Honorable Division Bench held that the 2011 notification will not, the memoranda will not have any applicability to him, because it is of prospective nature, not retrospective. So this petitioner, Ekteshwar, was not covered.
As per
this decision, which you have handed over.
And with regard to the second judgment, Lordship will have a look.
Actually, that's the first.
And another one I have already handed over.
Hemanto Das Boiraggo, that was the first judgment.
Same thing.
More or less prospective aspect.
Then
But
how will
here-
you be covered?
No, herein Lordship will kindly have a look what as per their memorandums are concerned. Now, for a moment, Lordship, kindly turn to page 41 for once, which is the actual memo initially came in the scenario that is of 2011. What is being stated?
Yes.
Lordship, so?
No, tell me.
Yes.
Lordship has found.
Lordship will look. In order to provide security of tenure, appropriate emoluments and certain terminal benefits subject to the fulfillment of certain conditions to the casual delegated contractual workers who have remained engaged in the various government for a considerable period of more than 10 years in connection or implementation of various schemes, projects of the various departments of the governments, two memorandums such and such were issued by the government or the finance departments. The question of making the provision of two aforesaid orders more effective and suitable to the convenience of the government establishment and organizations have been under consideration of the government for some time past. After careful consideration of the matter and superstition of the aforesaid orders and all orders issued by the departments of the undersigned is directed by the order of the government to say casual delegated contractual workers who are remaining attached to the various establishment of government department directorate regional offices not less than 10 years continuously as of 2011 and have rendered services for 240 days each year are allowed the following benefits. The casual delegated contract who have rendered 10 years of service continuously at least 240 days of attendance each year may remain engaged in the same status and capacity at the age of 60 years. The continuity of service shall be certified by the competent officer not below the rank of assistant secretary in the case of the secretary department, director in the case of directorate, and assistant engineer and skipping home. An entry point of
Come to 9. Come to 9.
9. It is reiterated the officer responsible for any further engagements of casual debt will be personally liable for the violation of this order. However, having regard to the exigencies situation, the order to facilitate smooth running of any project administrator serving interest wherein the absolute necessary contract may be made for a limited period not exceeding 1 year. This engagement may be made in strict observance of the recruitment rules and showing sanctioned vacancies. Simultaneous steps may be taken to fill up the vacancy on regular basis following recruitment rules. Such contracts may be renewed from time to time, but not the 10. The provisions of this order will not be applicable.
Will not be applicable.
Yes, where contractual engagements has been made without any sanction post. Now, I'm coming, Lordship, kindly have a look. I have been.
Mr. Banerjee, for the application of this, you have to show me that you are appointed to a sanction post. End of the matter.
Yes.
If you can show me, you're through. If you can't, thank you very much.
First, Lordship, kindly have a look at the interview.
Who is the gentleman behind you whispering into your ears? Ask him to move back. Further back.
Yes. For a moment, Lordship, kindly turn to the interview section, which is on page 15.
1.5.
1.5 and 1.6. Kindly have a look at my appointment letter. It is to inform the governing body of this college is pleased to appoint you as such as such in college. The scale of pay is such as per existing government rules. If it is without the sanction
Sue the college. Sue the college.
Thereafter, Lordship will find the entire amount will be recovered as and when your pay announcer will get from the DPI. And they have already forwarded same to the DPI. Can you have a look?
Mr. Dotto, can you inform whether these are sanctioned posts or not?
Not sanctioned posts as submitted by the college authority. Lordship kindly sees, but I just take the Lordship.
No, I'll come back to it. I just wanted to know if it's a sanctioned post or not.
Lordship kindly have a look whether this at all applies on page 41. Kindly have a look at the initial. In order to provide security of tenure, appropriate emoluments and certain terminal benefits subject to fulfillment of certain conditions to the casual delegated contractual workers who have remained engaged in various government establishments for a considerable period of more than 10 years in connection with the implementation of various schemes, projects of various departments of the government. Again, of the government.
Does not cover schools.
Second paragraph.
Does it not cover schools?
No. It's not a government establishment at all.
School, not college.
So on the face of it, on the first two paragraphs makes it clear to whom it will be applicable. This is meant for the casual workers engaged in various government establishments. Repeatedly said government establishment, then department of the government. Then second paragraph, question of making the provision of the two aforesaid orders more effective and suitable to the convenience of the government establishment organizations. This is college gets the government grant, government aid. It doesn't make it a government establishment or organization at all. So therefore, this memorandum has no application in this case.
Well, this has been adopted by the Higher Education Department. Page 36. Now, you have a look. It's keeping over these things. 36 will reveal. This has been adopted by the Higher Education Department. The college can't under within the ambit of the Higher Education Department. I mean, if a person is working for continuously for 10 years, even he is entitled for the regulation. Latest judgment of the Supreme Court is also in the field. I am not pressing hard.
No, Mr. Banerjee, with due respect, it says different offices under the control of the higher education. School is not an office.
No, even Lordship will find from here in itself, go to page 31 for once. First 31. This was the memo being put forward to the government. Kindly have a look, third paragraph. Further resolved, Lordship was found that the following persons be appointed as a whole-time basis as non-teaching staff from the panel for the appropriate scale and pay and when sanctioned from the government on purely temporary basis. Now, I am not pressing hard over the regularization. Even to, if your Lordship be with, if your Lordship kindly hear me, if a person is working for 10 years, the latest Supreme Court judgment who is already in the field, which says I'm entitled to regulation also. I'm not pressing hard for the regulation, but at least what the other people are getting in terms of what is the purpose of coming with this regular memorandums?
It's not for you, right? It's not for you. The memorandum's purpose is very clear, but it's not for you.
But memorandum is benefiting me.
No,
Lordship
it's
will
not.
find-
It's not applicable.
Now, if your Lordship be with on my initial appointment.
Ashun,
Kindly.
Ashun.
Well,
No, let them file an affidavit. Otherwise, it's useless. The matter is required to be heard on affidavits. Let affidavit in opposition be filed by 30th April 2026. Reply thereto by 15th May 2026. List this matter in the monthly combined list of June 2026 for further consideration. Under the heading hearing.
Lordship is given 30th
April
30th
15th May বললাম
মে মাসে
শুনতে পেলেন নাকি? Yes.
মে মাসে June. Okay.
Yes. Call on the list.
30 Lordship can pass the same order.
Very well. Item 30, Nandi Babu, same order হবে. Yes. ডাকো 31 ডাকো. 29.
কতটা?
না 29 হয়ে গেল, 30 হয়ে গেল তো.
No, my lord,
28 and 30. আচ্ছা. Yes.
28 and 30. 30.
মশলাটা গরম হয়ে গেলে এটা হচ্ছে one of
ওর অ্যাপিয়ারেন্স তো আমার সঙ্গে আছে।
Hello, Lordship, in the year 2023-24 and 24-25, affiliation by PCI, approval by PCI and State Council, affiliation has been given. We are running that college. 2024-20. Now, my lord, 2 years has been given. Lordship, only one inspection report. I want to show your Lordship page 46. Page 46.
Madam, your matter is a pension matter, that 195? 199. Mr. Chatterjee, you're there. Just we will take it up after this matter. Yes. Or you want to come back at 2 p.m. Come back at 2 p.m. then, because from 2 p.m. I'll take the pension matters. It will be the first 195 to first again. Whatever. Yes.
I have 2 fixed matters at 2 p.m. before the division bench.
No, the pension matter.
In that matter also I have to pay.
Oh.
Is for the state and is for the council, university.
Asha, then wait till. Can your matter wait for 1 day?
Madam?
Huh?
To me?
Yes.
It can be done after this. I don't think.
No, there is no urgency. She's been coming every day and eating my head off. Just wait for 5 minutes. Let me take up that matter. Is there any scope for interim order?
I will take only a few minutes, my lord.
Everybody will take a few minutes.
5 minutes. Kindly see page 46. Kindly page 46.
Is there scope for any interim order?
Well, in my opinion, it is to be disposed of by your lordship.
Tell me. Yes.
Page 46,
yes.
lordship, kindly see. During inspection, lordship got it.
Yes.
Previous inspection order. During inspection, it is observed
Yes.
that classroom and lab room, common room for girls and boys, and toilets are good and cleaned. Equipment of laboratory are sufficient. Surplus staff, teaching and non-teaching staff.
This is PCI inspection report.
This is inspection report of council, state council. State council.
Very well. Then?
All are mentioned very well. So inspection report on the previous years, in 2 years, that is in my.
This is of 2023.
No, 2023, 2024, 2025, 23, 24, 24, 25.
Yes.
Inspection report is good.
Yes.
All apparatus are correct.
Very
all
good.
infrastructure are correct.
Very good.
So now I am in better footings than PCI has already given me approval
Right.
for the session 2025, 2026.
Very good.
But only some deficiency has been shown by the State Council. In previous 2 years, they have not shown any deficiency.
Very good. Deficiency can happen.
Well, how it can be previous 2 years when the approval application was given?
Your car is in wonderful condition today. 2 years later, 2 years you have not serviced the car, it won't start.
The building is new one. The college is
Maybe
new.
building, there's a question of maintenance. Building might be new.
And not such kind of, there is a common room on the previous occasion also. Now they have what deficiency they have shown, Lord Chief Kindly.
I'll direct you to rectify these deficiencies.
Lord, I have already.
And very good.
Lord Chief kindly come to page.
If not already done, Puranam.
If he has already done, you cause a surprise inspection again.
P30.
Cause one more and say that they have not rectified. End of the matter.
What occasion this further inspection, although the Act provides the responsibility upon us to pause year to year whenever we feel it necessary. Now, after the order, we are duty on. Only this marked
No, so what do you propose to do?
expert committee was
Yes.
colleges that found that yes, it can be cured. But here, that same one, this expert committee appoint. We are having this expert committee for the honorable court that for this college, that re-inspection they have not proposed because it is not curable. They have cited the reasons.
What are the deficiencies?
Deficiencies in classroom is shorter than this is specified by PCI. Earlier, we have allowed for certain reasons.
My PCI has given
earlier after that order.
Classroom has become shorter in 2 years' time.
No. Earlier also.
Then you have allowed. Why won't you allow now?
Only not that is a small aspect.
And PCI also allowed. Already allowed.
PCI cannot because PCI never nowadays PCI never goes for physical inspection on the basis of their SIS standardized information format. They give the application based on our final application. The apparatus, all these things, we found it not in proper manner, not in use. It cannot reflect.
Show me where you have made these comments.
Yes.
And the PCI also recognized us as per section 12 because the performance is greater. That's why under section 12 they have already. Also, I am showing that document.
Yes. Expert committee signed by the last page. The continuation of the inspection conduct is
What is specified by the PCI norms?
Laboratory and live. During the inspection, the following group sizes were recorded. Classroom 1 approximately 50 square meter.
No. What is the PCI norm? Show me.
That the PCI Act, my lord, I have to.
Because I will pass a stricture against PCI for allowing them for the past 2 years. You wait and watch. No, of course you may. Of course you may. I will pass a stricture. Who is the highest authority in the PCI? Director.
Mr. Tiwari earlier appeared.
How did you allow it? If 75 square meters is the norm, how did you allow? If you are saying you're the state council, you just said on my recommendation, PCI gives the just now you've said what? No.
Not PCI.
You said PCI does not conduct any physical verification anymore. Whatever we say, PCI on that basis gives the nod. Mr. I'll haul up the entire system now. Please, don't make submissions by waving your hands and creating a dance situation here. Please, you are saying 75 square meters is the classroom size. And because they have 50, you will not allow. Absolutely justified. Why did you allow for the last 2 years? It's not that the classroom became smaller.
I might know that, my lord, this thing may, my lord, for lordship, I have the answer to that. Earlier, this we have to, the inspector we used to say, my lord, that are lots of colleges.
Your inspectors have indulged in heavy artillery cash transactions.
No. That, my lord, we cannot say because that was for this other, if we find that others are in proper form, that for the smaller.
Mr. Roy, simple question. If 75 is the base minimum, for the last 2 years, how have you allowed 50 square meters? Tell me this, or you're off.
They used to visit the colleges. They found that these are the classrooms are available. They used not to take this proper measurement, and there were some of the colleges and the other the government found the employees.
The more effort you put into it, the more convinced I'm becoming, and the higher it will go. When I clamped down, I started with the inspector, inspection report. Now I'll go on, director, whoever's the topmost person, I'll haul him up.
After the honorable court's orders, we have to be specified, and we are sending this technical sound persons like this.
You will file a report, and no. What? Yes. What?
We can clarify in the report.
No. I don't want any clarification. You will file a report explaining why, for the last so many years, you've not conformed to the PCI norms.
Apart from that, only apart from the classrooms, there are other.
No, there has to be some end, some finality.
No, only one annexation. Yeah. Only.
What purpose will it serve?
PCI.
You are also you're also there involved in this nonsense. Of course, your clients used to pay money and get the certificate done. Please. The petitioner is aggrieved that they have not been given the requisite certificate from the concerned authority, namely the State Council. Stop. The State Council has opined that there are certain infrastructural deficiencies insofar as the petitioner is concerned, on account whereof the affiliation cannot be made. Stop. Next. It is surprising to note that for the last at least 2 sessions, the State Council has granted the certificate of, what is it called?
Affiliation.
Certificate of affiliation upon inspection to the very same college of the petitioner. Stop.
And PCI gives
the State Council, who is the authority?
State Council.
The respondent number 6. No.
I'm coming.
Who is the state?
State Council, highest.
Respondent number 2.
Senior Administrative Officer.
Westmoreland State Council of Technical and
Chief Administrative Officer of the West Bengal State Council of Technical and Vocational Education and Skill Department
Development
will file a report by April 30th, 2026 by way of an affidavit as to how and why deficiencies of the petitioner for the earlier years were glossed over and or deliberately ignored while granting the affiliation. List this matter on May 2nd, 2026, May 5th, 2026 for further consideration.
Only note down, the PCI already given approval in this year.
Very good.
25-26.
PCI will also be caught in the net. Wait.
I have already given, and they have also
Dako 199 to Dako.
The matter will appear on
5th of May. 5th May. They'll file the report by 30th April because they'll come and say we are all very involved in the SIR, can't do anything. So by 30th April they will file, and 5th of May.
5th of May.
Affidavit certificate.
Yes, affidavit of service as file be kept on record. Yes. 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 Yes, Mr. Chatterjee.
Well, I'll try to show, Millard, I am not the mystic maker, Millard, I am not the bottleneck. I will kindly come to the prayers of the repetition, page 21.
Arey, Mr. Chatterjee, we'll get over all that.
On a
Old
lighter
lady.
note, sometimes
Old lady. You are, I have known you as someone who always works with a heart.
True, Millard. Page 21, Millard, he falls, Millard, in fact, Millard, she falls short of 10 years by 1 year and few months.
6 months is the cap. You can.
In many cases, Millard, the courts, our courts, Millard, have come forward in favor of the incumbent and has allowed. Well, that is not the question, my lord. Why, my lord, I invited your lordship to come to take 10 to come to page 21 is
Yes.
my lord, the previous, my lord, she is asking to count the service rendered as research associate. Just a minute, my lord. My lord, research associate from the period 85 to 90 as extraordinary leave. So this 5 years before joining the post, she has served as a or
Research
worked
associate.
as a research associate. Because she now wants that this period to be treated as extraordinary leave. Let me kindly take the relevant law in this regard.
No, my lord.
That- So these are the DCRB rules, my lord. Chapter 4, my lord, deals with rules of recording of service. I'm sorry, my lord.
Huh? Yes.
Lord, chapter 4, my lord, second page of this, my lord, deals with rules of recording of service. My lord,
Yes.
my lord, kindly come to section 28, period of leave at the bottom.
Yes.
It says, my lord, all period of leave other than the extraordinary leave without pay shall count as service. So extraordinary leave will not count as service.
Oh, other
may-
than extraordinary.
Right. Let me I continue. There are, my lord, riders to this. Sir, it says period of extraordinary leave. All extraordinary leave granted on medical certificates shall count as qualifying service. So, if it is on the score of medical reasons with medical certificates, it will count as service. Lord, provided that in case of extraordinary leave, other than extraordinary leave granted on medical certificates, the appointing authority may, at the time of granting such leave, allow the period of that leave to count as qualifying service if such leave is granted to the government servant. I will kindly turn the page. Due to his inability to join or rejoin duty on account of civil promotions, B is for prosecuting higher scientific and technical studies. Higher scientific and technical. Here it is Sanskrit. So, my lord, reading this, my lord, it does not fall under any circumstances. She cannot, her service rendered as research associate cannot be counted in terms of these rules to be service. Now, my lord, I'll show, my lord, that the state, whether she is entitled to the pensions or not, is, my lord, pending with the state for the time being. My lord, will kindly take the first document, page 30. Let state raise certain questions. Page 30 and 32, my lord, will find. 32, my lord, kindly state come to. We must endeavor to save my lord's valuable time.
Yes.
These were the queries, my lord, raised by the state. So, my lord, the issue is substantially lying with the state authorities for our decision. My lord, will kindly turn the page. Next page, my lord, we have forwarded the necessary documents to the state authority. My lord, thereafter, my lord, will again turn the page, my lord. I'm sorry for troubling your lordship. My lord, this is a letter of 29th, page 34, 29th March 2022, page 34, my lord.
Yes.
My lord, the second paragraph of this, my lord. Consequently, I am further directed to request you to kindly furnish relevant information, documents considering whether the period of such and such as a resource associate under UGC is countable as a regular service for pension at the earliest, so that the matter can be taken up with the finance department pension branch in due course of this statement. Whether third clause of this query, third query of this letter, whether her service as a research associate was continuous within the jurisdiction of the state government as per provisions of memo laid down in such and such. And next page, my lord, will kindly turn, my lord. We have already replied. Page 35 is our reply. Page 35, your lordship, see. So, my lord, we have sent this. We can resend this and let the DPI take a call.
Who will be the authority? DPI.
DPI will be the authority.
Then, Mr. Doctor, let the DPI decide within a stipulated time.
Yes or no, if it comes, your lordship can decide.
Provided the university supplies all the documents as requisitioned by the letter dated 29th of March.
29th of March, page?
Page 34.
No, 34 they have already submitted. Oh.
No. It's page 34 is not the reply. I'm sorry to say. It's not. It is the internal communication between the university and the registrar.
Correct, you're right. Mr. Chatterjee,
communication.
35 is submitted to the registrar. Not once again, you have not sent it at all.
I don't know why he said, Mr. Chatterjee. This is a reply to this letter. It is not a reply.
Correct. Sent to the. You send it by 10th of April.
Just now my learned friend has pointed out the prayer portion. I never said so that the research associate period treated as a extraordinary. 85 to 90 I worked as a research associate. Thereafter I worked the university, but no record is there. Ultimately 2000 they have appointed me as a lecturer. When I see the appointment letter, first blood. That is 25.
Yes.
10 years gap. 2000 I appointed as a lecturer and continued up to 60. Thereafter they have extended my service till 65. And from this appointment letter, your lordship will see, that is the third paragraph. The joining report along with the last copy of the pay certificate for fixation. That means they are relying upon my associate research associate last pay certificate. So my humble submission.
You take all these points before the DPI.
Yes. Because lady 77, I don't know whether during the lifetime she will get the, because your lordship will see the later
So
correspondence.
the DPI will decide by April 15th. Madam, what's your, I can't understand. By 15th of April, DPI will decide.
Let the matter keep trending.
No.
Then I have to come.
Before that, lordship can direct the university to supply.
Yes, of course. The petitioner.
Correspondence has been maintained between the university and higher education department. Since long, Lord.
The petitioner has aggrieved that her pensionary benefits are not being released on some pretext or the other. Stop. In fact, all her documents and requisites have been submitted with the university and are lying with the university. Stop. The respondent number 8. Now, the only next paragraph. The only concern is the service record of the petitioner and the continuity thereof to ensure as to ascertain as to whether she is entitled to the entire pensionary benefits as claimed. Stop. Next, the respondent number 8 or 9. The DPI, you have not made the DPI a party. Parties, I have been informed that the entire matter is pending before the Director of Public Instruction. Stop. The same has been pending as the respondents have not. The respondent university has not forwarded the requisite documents to the Director of Public Instruction. Stop. I direct.
Later dated 29th of March.
Stop. I direct the respondent number 8 to immediately forward all documents in terms of the communication of 29th March 2022 by April 10th, 2026 to the Director of Public Instruction Stop. Next, the said Director of Public Instruction will thereafter hold a meeting. Now, will upon adequate notice of hearing to the petitioner, conduct a hearing and dispose of the matter by April 25th, 2026. Stop. The resultant order of such consideration will be communicated to the petitioner by April 30th, 2026. Stop. The petitioner will be at liberty to use any further documents, to disclose any further documents that she wishes to rely upon before the hearing, at the hearing before the Director of Public Instruction. Next, with the aforestated directions, the writ petition is disposed of. There shall be no order as to cause.
One injustice I'm
Yes.
bringing, one injustice. But the DPI is unwell, he is in hospital, I'm told. So in one of the matters where he has not been able to communicate the order, acting upon an order passed by Lordship. So, Lordship, a little more time be given.
Tell me, 15th May?
Yes, I think.
By hearing by 20th April na kore, hearing by 15th May, or communication by 25th of May. Resultant order be tale respondent number 8 by 15th May korbe. Hearing by 15th April, sorry. By 20th April, since 15th, by respondent number 8 will forward by 20th April 2026. DPI will give hearing by 15th May, communicate by 25th of May. Yes.
Sir, my humble prayer and thanks with the matter.
No, madam.
If that please keep my favor on that day, your doctor can dispose of the matter. Otherwise, again, the lady have to come.
ডিপিআই করবে 15ই মের মধ্যে হিয়ারিং দেবে 25শে মের মধ্যে রেজাল্টেন্ট অর্ডারটা জানাবে ইয়েস আরেকটা বাকি রয়ে গেল না 31 দুটোর সময় আসেন
Okay.
3.
I have put the statement.
Who's the petitioner? Not today. What more do you want me to do, Mr. Dev? Out of turn mentioning, first mentioning refused. Out of turn I give you. You go away at 12 o'clock. Matters called on, you don't appear. Why? Where are your juniors? You're a senior advocate. Where are the mighty juniors of yours? Take them to task, I'm telling you. High time. You and I have been too good at the bar. Now go 31. Mr. Dev, Mr. Shopon Datta was there. Learned GP was there in the morning. The DPI is supposed to do it.
Yes.
He is not well. He's in the hospital.
I have no problem.
He has told me.
I have no problem.
What? Tell me now. What is the instruction, Mr. Dashgupta? You tell me now. I'll believe you. Admitted to the hospital. Yes, that's I know.
I have no problem. The interim order not to fill up the post is till today.
No, now I have to pass a fresh interim order.
Yes, that prayer I have made, Millard.
You've annexed that order?
Yes, yes. Page Millard 30.
31.
Page 34. Millard. Page 34, internal page 6, Millard, 39. Paragraph.
No, what is 42?
Millard?
42 is your matter.
No, Millard.
Yes, 32, 42, page
yes,
42.
Page. Yes.
Yes.
Page not the age nahi.
42 is the order, 39 is the order.
Same order.
Same order, because after the order was passed, that was communicated to the authority to act in terms of order. So Lordship can come to page 39.
No, I'll come to 42. I'll
42,
42
very
better.
I would come to 42. 47.
Down order, it a down instruction.
Kindly comes to page 47.
Yes, Mr. Dashgupta, you keep the post vacant till he is back. When will he be back in service? Left upper limb. 15th May. You complete this process by 15th May. I thought you were messaging someone. কাকে করছে না বললাম না হ্যাঁ I'll give him till 15th of May. Let him take the decision and communicate, and the post will be kept vacant till 15th June. Yes. Ashun, the instant writ petition is primarily and has been made primarily to seek execution of the execution stroke implementation of the order dated January 30th, 2026, passed in WPA 1667 of 2026. Stop. The said next para. The said order directed the director of public directed the respondent number 2 therein, comma, the director of public instruction, comma, the respondent number 2 herein, to decide on the issue of transfer of the petitioner within a stipulated date and to communicate the same to the petitioner by March 25, 2026. Stop. It was also directed that the post of assistant professor in physiology in the reserved category, comma, which has been lying vacant for a long period of time, shall not be filled up till March 31st, 2026. comma, in view of the transfer pending consideration by the respondent number 2. Stop. Next, the instruction of the state respondent, comma, is kept on record. No, kidding. The present writ petition is on the grievance that the respondent number 2 has not complied with the order of 30th January 2026. Stop. Next, the instruction of this. Now, Mr. Dashgupta hands over a copy of the. What is this? What, Mr. Dashgupta, handing over whatever you feel like. A communication from the Deputy Secretary, comma, Deputy Secretary bracketed law, comma, Department of Higher Education, Government of West Bengal, dated 30th March 2026 is kept on record. Stop. It appears from the said instruction that the respondent number 2 is struggling with health issues and was admitted to the hospital. Stop. In view thereof, comma, I direct the respondent number 2 to carry out the directions contained in the order of 30th January 2029 with enlarged timelines. Stop. The hearing, has the hearing been held?
Yes.
Oh, that has been done. I see. And he has not communicated the order.
Only the communication.
Stop. With enlarged timelines. Stop. Since the hearing has already been held, comma, the respondent number 2 is directed to take a decision by April 20th, 2026 and communicate the same to the petitioner by March 30th, 2026. Now they will manage, they won't manage. Sorry, April 30th, 2026. PARVIN April 30th. By May 15, 2026 and communicate the resultant order of such consideration to the petitioner by May 25th, 2026. Stop. Next, the post of Assistant Professor of Physiology, in which school, Mr. Dev?
That is
number. Yes. In the respondent number 5 will be shall not be filled up till June 15, 2026 or until further orders or until further orders from the respondent number 2, comma, whichever is earlier. The writ petition can be disposed of with the aforestated observations and directions, comma, the writ petition is disposed of. There shall be no order as to cost. Urgent photostat, certified copy. Yes, Mr.
There is additional vacancy also, another post that I have annexed page 55. So if Lordship can take note of it, because at that point of time when I moved the writ petition, there was only one vacancy that was known to us, page 55.
Saleh will then he has to reconsider. He has to reconsider the issue.
At that, in the writ petition, the petitioners participate in the hearing and submitted petitioner participate in the hearing.
What will I say, Manoj?
No, sometimes say something.
Yes.
Sometimes say something.
I have matters. I couldn't go. I got the virtual connection because Lordship sat in time, so I have to be here. But they don't turn up.
Don't laugh. The senior is here, Mr. Chakraborty. What is this? Matter had been called on. I went on to 32.
Absolutely. You forced me to mention the matter yesterday when there was no mentioning. My lord entertained. Then at the time when the matter was being called on, you were not there.
Yes, Mr. Panda and the
petitioner participated in the hearing process, submitted a written notes of argument. In the said written notes of argument, the subsequent vacancy has already been
indicated তাহলে ওখানে যেখানে বললাম will কি বললাম will consider না communicate না তা আগে না will consider যেটা বললাম by 30th April ওটা কি বললাম will হ্যাঁ ওটা কি 15th May কি করবে হ্যাঁ take a decision in respect of the vacancy already provided in the respondent number 5 as well as in any other institute that may be available, including the post of assistant professor physiology of Midnapur College, bracket autonomous, comma, if the same is still vacant. বাকিটা যেরকম আছে থাকবে আসছে আবার
Can't change them. Always will come with a smiling face. Very difficult. Very difficult.
I always say that juniors being busy is a very good sign of the profession. That means the profession is rolling. But at the same time, sometimes they have to be, censored. Sometimes. Yes. Yes.
The petitioner praying for an adjournment for 2 weeks, my lord.
2 weeks? কেন কি হয়েছে?
Mrs. Kutia,
হ্যাঁ?
Mrs. Shobita Kutia is appearing in this matter, my lord.
Who, Mr.?
Mrs. Shobita Kutia, my lord. This on record. She is on record.
আচ্ছা, হ্যাঁ।
Due to her illness, my lord. That's why I am praying.
কি বলছে নিজের মনে গুজগুজ করে আমি কিচ্ছু বুঝতেই পারছি না আরে ইউজ দ্য মাইক্রোফোন লাউড
Yes, my lord, due to her illness I am praying for 2 weeks.
2 weeks but then it will go off more than 2 weeks because others have to get a chance আজকে কত তারিখ 31 তো 29th April yes yes
So in this matter I am appearing for the petitioner for pensionary benefit lordship. The petitioner was the headmaster of a school lordship, retired from service on lordship 31st of March 2023.
2023
thereafter lordship
not being paid
earlier lordship 2 occasion 2 writ petition was filed lordship. If your lordship
Yes.
kindly consider lordship the earlier order in page
Yes.
65. This honorable high court lordship
65
page 65 is the lordship order.
Yes.
The order in
Yes.
question. The last paragraph.
very well yes
Now this order was communicated. After communication, lordship kindly comes to lordship page 70 lordship. The memo was issued by the lordship Pension Provident Fund and Group Insurance Government of West Bengal in favor of the DI.
yes
For taking necessary steps, it is still pending lordship from 4th of March 2025.
Mr. Jan
I think he is not in need of any money.
Huh?
I think he has no need of money.
Why?
My lord, repeatedly he was asked to make some signatures and to hand over the
Already
copy.
done lordship.
No.
Pursuant to lordship earlier writ petition in presence of DI lordship, every pension paper and it was prepared.
Let me show you lordship, my lord. Kindly have a look.
no Mr. Jan then let me direct
Even
him
lordship,
to
where I have to sign lordship, let them speak lordship.
That
Before
was
the court,
sent to him. That was sent to him. That is received by him. We are ready to help him. These are the postal receipts, my lord, that they received it.
no this is pension file has been objected by the DPPG
That has been corrected.
acha
Now he has to put his signature in the e-filing system, e-file. Then he has to take out
e-filing
e-file.
that's where he is getting stuck
He has the login ID. He has the login ID.
Has it?
Then he has to take print out of part A and part B. The hard copy is to be let him come to our institution any day.
Any date lordship.
We are ready to cooperate.
tell me give me a date
Any date lordship Monday.
Monday
And it's any day.
Monday at 12.
the petitioner is aggrieved that having retired in March 23 and after approaching this honorable court on earlier occasions, his pensionary and retiral benefits have not yet been released. Stop. Mr. Jahan, appearing for the respondent, submits that certain signatures are required of the petitioner, of which he has been intimated, about which he has been intimated, without any response. Stop. The petitioner will visit the office of the
CRGS High School, Malad, Beldanga, Kashimbajaria, Raj Gobindo Sundari High School.
Respondent number
Lordship,
5.
May I submit one thing? This is a issue, Lordship, because Lordship, in the school I could not attend prior to my retirement because I was attacked by some person.
That situation is no more there.
Attend the office of the DI.
That situation is no more there. He knows it very well.
No, but better if he has an apprehension.
It's Monday, Malad, can you take me instruction? Can you give me to? Because Monday the headmaster has to go before the DI now.
Yes.
Instead of Monday, can you keep Tuesday?
Tuesday. I direct the petitioner to visit the. I direct the petitioner as well as the present. Who will be the disbursing authority? Present headmaster.
Hello.
Who is the present disbursing authority? Will be the headmaster.
Disbursing authority is something else.
PPG.
Yes. But I am the headmaster. I have to do all this TIC. I have to do certain.
The petitioner will visit the office of the respondent number 5. No. Visit the office of the respondent number 4.
4 is the DIS.
Along with on April 6, 2020, April 7, 2026 at 12 p.m. Stop. At the same time, the respondent number 5 will also visit the office of the DI, of the respondent number 4, to ensure that all requisite documents and other necessary signatures are affixed by the parties concerned to enable the pensionary and retiral benefits of the petitioner to be released in his favor. Stop. Next, this exercise of releasing the pensionary and other benefits will be done by April 30th, 2026. With the aforestated directions, the petition is disposed of.
People keep the matter pending for compliance, Lordship. Because Lordship, earlier occasion it was direction.
Contempt. One good thing is my orders, nobody violates.
Frame the time, so
Nobody violates my orders.
grateful, Lordship.
Yes. 33 ta kilo. Yes.
But in this matter, my lord, petitioner.
34. Yes.
In this matter. Yes, I.
This matter.
Yes, my lord. I am saying that. But in this matter, prefer an appeal before the division bench.
From what order? What is the order?
Order passed by the Honorable Justice Mantha, my lord. Kindly see this order.
File in can order ta? Order ta file in. In this matter.
In this matter. I mean, the matter related to CPF to GPF area pension interest.
Oh, I see.
And this order passed Honorable Justice Mantha. And according to this order, government prefer an appeal. Appeal is pending before the Honorable Justice Tawputo Chakraborty Division Bench. And matter appearing in the list, number is FMA 937 of 2024. Item number.
This matter, there is no appeal. Similar matter.
Similar matter, my lord. On that ground, I am praying to adjourn 4 weeks. In the meantime, I think this will be disposed of. I think, my lord.
In view of the parties submit that learned advocates appearing for the parties submit that an appeal is pending on the self-same issue as involved in this writ petition before the Honorable Division Bench. Stop. Let this matter appear in the list. Now, the matter is adjourned with liberty to mention as and when the Honorable Appeal Court decides the matter finally.
Yes, my lord.
Yes.
Next.
কি দরকার বললে তো সব থেকে ভালো হয় চিৎকার করে মাথা খারাপ করে দেবে সে কারেকশন করতে বলবে
অসুবিধা নেই
না একজন সাইনেডাই মানে আর মেনশন করতে পারবে না, মাথা খারাপ করে দেবে। একজন সাইনেডাই
No, my lord, I'm my prayer, my lord, kindly make it monthly list of May, my lord.
you mention it, we'll take it up as and when you mention.
Yes, my lord.
I haven't fixed any date. You once that is over, you mention, we'll take it up.
Yes, my lord.
Yes.
35 similar prayer.
Similar. Very good. Mr. Yusuf, you're there in 35?
Yes.
Yes.
Same prayer, my lord.
Yes. Just give the appearances. Mr. Arifin, give your appearance. Mr. Yusuf, appearance.
Same, my lord.
Tell me now, 35 থেকে কত?
35 to 39, my lord.
35 to 39. Very good. This is CPF to GPF.
CPF to GPF, area pension interest.
And area pension?
Pension interest. Pension I receive, but not given interest. On
Not
that,
given?
Not given interest, my lord.
Interest. Achha. I see. Very well. Finally adjudicates the matter. But আপনি কি করতে চাই? Finally decide the matter. যদি finally decide না করে appeal court যা কিস্তি করছে আমাকে, কোর্টের ভেতর করতে পারছি না, বাইরে করছি, বলছি তো ওরা হাত দিতে পারছি না। 39 অব্দি হয়ে গেছে।
39, my lord. 38, I am for the state, my lord.
Submit what? What report? I am not asking for any report, but give your appearance.
40, my lord, same prayer.
Same 29th. ওইটা 29 ছিল তো
First, my lord, 32. There was 32. Yes, 29. Yes,
হ্যাঁ 34 to 39 same order.
My lord. 40, 41 and 42 also.
40, 41, 42. All 29th. Yes. Yes, which one? 41, he's prayed for an adjournment on the ground the petitioner's advocate is not well, kept on the 29th of April. 29th of April. না 29 ভুল বললাম, পেনশন তো 28 এই কথা গেল 28 পেনশন ইজ অন টিউসডে না?
Yes, my lord.
28 হবে, তুমি কিছু বলছো না, সব গন্ডগোল হয়ে যাবে, ওইগুলো 28 করে দিই।
Yes, my lord. 28.
Yes.
My lord, I beg to appear on behalf of the petitioner.
Yes.
My lord, over here, my lord, the petitioner has retired from service on 31st December 2024.
Yes.
Kindly takes your lordship's order dated 27/10/2025.
Yes.
The synopsis has been given.
Yes.
Later on, there has been a subsequent development by which the NOC.
Who is for the respondent?
My lord, Mr. Shaunak Bhattacharya and Oyun Banerjee is appearing for the respondent. We have also given the notice that the matter is appearing today also. We have been mentioning many times, we have been giving notice also to them. So that, my lord, only one small prayer, my lord, the dispute with regard to the NOC has been sorted out by the school authority because because the board has ultimately found out that the allegation which has been made by the lady teachers was found to be vexatious. My lord, this is the supplementary affidavit.
Mr. Banerjee, should I pass it over? It can be sorted out in 2 minutes. Ring Mr. Shaunak Bhattacharya, ring Oyun Banerjee, bring them. I'll just pass it over. It can be disposed of today only.
My lord, I am praying because since the matter is pending before your lordship, they are not releasing my pension.
Just get them. I'll record that it's that complaint has been dismissed or disposed of, whatever. Therefore, you are entitled to the pension and pass the order.
Only with regard to the interest.
Don't listen to whatever Mr. Boiddu has to say. He will not stop. You ring Mr. Banerjee or Mr. Bhattacharya.
Yes, ma'am.
Pass over. 42 to 43. Yes.
I'm on behalf of the petitioner lordship led by Mr. Noyan Chat Bihani.
Where is he?
He's engaged in another court hearing, lordship.
In another court? Why? He doesn't like this court.
No, lordship.
Then? What do you want?
Accommodation, lordship. Accommodation for today.
Accommodation? Like a flat or a house?
kindly fix this matter on any day next week.
Today is fixed. Passing it over. Call him. Call him. Call him. Passing it over.
Hearing on behalf of the petition.
Yes.
Petitioner retired from the service. Read us that.
Yes.
Petitioner retired from the service in the year 2025, but till date, not get pension. The reason is mentioned in page 40.
Why is he not getting the
higher
pension?
pay scale is not approved. It shows, higher scale approval is wanting, or
where are you
page
reading?
number 40, observation.
Yes.
What? Higher scale of approval is wanting, or up to date overdrawn amount is to be deposit to the treasury challan. I complete my higher education.
I have
MSc
instruction. I have an instruction. In this instruction, it is clearly stated that this office objected that without getting approval from DI, Secondary Education Hooghly, Srimati Kaveri Chatterjee enjoyed master degree scale from 25th January 1989 before retention, my lord. Because in this report is stated, my lord, that without any information that Kaveri Chatterjee enjoyed the total salary.
Without any
information, prior
information.
That
she had acquired a higher degree.
Kindly turn page number 21, I complete my higher MSc degree in the year 1989, Thereafter, school authority passed the regulation. On the basis of that regulation, that is annexed page number 22 onwards, 22, 23, thereafter 24, the most important page number 25.
Then
everything is sent
no,
to
I'm
the
asking him then.
And thereafter, several times, they were ROPA on the basis of the ROPA.
Are wait now? Oh, yeah, I was shuru kurle thamte jan.
May I give the instruction, my lord?
That is your instruction. You keep it.
Okay. In মানে বলে দিয়েছেন।
Tell me.
Yes, my lord. My lord, in this instruction, it is stated that before entering,
before
the office objected that without getting approval from district inspector of school secondary education Hooghly, Srimati Kaveri Chatterjee enjoyed master degree scale from 25th January 1989 before retention of her post, since she joined to an additional post.
If you can make head or tail of what you've just read, congratulations, because I couldn't. Could you make head or tail of what you've just read? Could you make any sense of what you just read out? Ki mushkil.
Malad, in this instruction, that Kaveri Chatterjee didn't take any
approval. Kaveri Chatterjee did not take instruction, did not give information. She has acquired the degree.
I'll take instruction, my lord. Further instruction, my lord, I'll take.
Till now, only the DI wanted instruction. Now you also want instruction.
No, I'll take instruction from the DI further, my lord.
Mr. Swami, why don't I direct the DI to dispose it of within a specified time?
Within the specified time. Because of that, my lord is well aware the fact that Rafiq Mashi, concerning the Rafiq, he enjoyed since 1989 till her retirement, 2025. Rafiq Mashi, 2015, 4 for para 18. I believe it's my.
Wait.
Following that, 2016, 14 SSC 267.
No, followed also in 2023.
Yes. That Rafiq Mashi is the base. Thereafter, my lord,
23, I think Justice.
Not only that,
Rafiq Mashi না এটা না তো দেখো বার করো তো রফিক মাসিটা 2015 yes
penultimate paragraph, paragraph 18.
Paragraph
18 most probably.
No, before that, there's one paragraph which
12
gives the A.
observation, it is not possible to postulate all situations.
All hardships and
Yes.
difficult situations. What I got paragraph 10.
Paragraph 18, probably in Indian
Yes,
it shows
18.
paragraph 18. If I'm not wrong,
Yes.
because in my mobile it shows Indian Kanun, that is paragraph 12.
Indian Kanun is not reliable.
Yes.
Not reliable.
Now, my Lord, Supreme Court says not even relied upon the SSC also, relied the main judgment. Why? Because
Not even the SSC online.
The recent,
but SSC online is more or less.
Most of the is all right, but some of the situation, my Lord, some of the paragraphs, my Lord, because Supreme Court now started the neutral citation, INSC.
Yes, now the INS
INSC says
the petitioner is aggrieved. When did she retire, Mr.
2025, retired from service.
Give me the month. The petitioner has retired from service sometime in 2025.
30 April 2025.
Upon completing several years of long and unblemished service. Stop. However, the petitioner has not been paid her pensionary and retirement benefits. Stop. The respondent number 4, instruction by DI.
Yes, Mala. DI Hooghly.
The Mr. So-and-so appearing on behalf of the state authority or respondent authority submits that the respondent number 4 has been unable to consider the case of the petitioner in view of the fact that the petitioner had rendered had obtained the pay scale of a master's degree holder, comma, without giving requisite information to the respondent number 4. That's what the instruction says.
Yes, Mother.
Stop. Next. The documents appended to the writ petition clearly disclose that the petitioner had obtained her master's degree sometime in the year 1987.
89. Master degree 89.
Oh, what is page 21?
Sorry, yes, 87, and it is communicated in the 89. See, getting master
87,
from 89.
comma, which was duly communicated in the year 1989. Stop. Next. In view of the aforestated, comma, the respondent number 4 is directed to consider the case of the petitioner, comma, strictly in line with the decision of the Honorable Supreme Court of India rendered in State of Punjab and others versus Rafiq Masi, M-A-S-I-H, Rafiq Masi and others, bracketed 2015 4 SCC 334. Stop. Next, the entire exercise of considering the petitioner's case will be completed by the respondent number 4 by April 30th, 2026. Stop. The resultant order of such consideration will be communicated by the respondent number 4 to the petitioner by May 15, 2026. Stop. With the aforestated directions, the writ petition is disposed of. No order is to cost. An opening affidavit of service as filed be kept on record. Yes.
Within a stipulated time.
I've done that. 30th April.
30th April.
By 30th April. Communication by 15th of May will be the consideration by 30th of April.
Okay.
Yes. পেনশনের এগুলো একটু ওপরে তুলে দাও। এটা কি? এটা না দরকার নেই আর, কারণ এইটার এইটা একই। হ্যাঁ, তো এটা থাক।
release of the pensionary benefit who retired from the service on 31st January 2023. Well, the subject matter of the challenge is page 40.
31st of January 23.
2023.
Yes.
Now, while the subject matter of the challenge, the objection raised by the authority on 19th January 2023.
Page?
Page 40.
40.
40.
Well, thankfully my copy is not paginated. So
Exactly.
after 29 there are no.
After 39.
এটা কোনটা 20 এটা কোনটা দিলে?
ভুলভাল বলেছেন নাকি?
26244 না দেখো রিট পিটিশন লিস্টে কি এসছে
26244
26244 46. There are only about 32 pages in the writ petition. 29, 30, 31, 32. দেখো? Yes. Huh?
Extremely sorry, there's no extremely sorry. It is my fault.
No,
This
no,
fault
no,
is
sir.
my fault.
That
Can
is
you
all.
permit me, my lord, within a minute, if your lordship can you permit me?
To do what?
Page marking.
No, but there is no page 40.
No, this is our page is 40, but it has not been paginated.
No, that's all right. The pagination I will do. That's not a problem. But
Your lordship permit me,
anyway. তাহলে পরে যেটা পাস ওভার হয়েছে ভাস করে মামলাটা রাখুন 44 না 43 or 44 43 টা রাখুন Mr. Bari, in the meantime there is one matter which is passed over, we'll take that. Yes.
Mr. Bhattacharya.
What, I have to now go and invite you?
I was appearing in another matter. Extremely sorry, Milord.
Where is Mr. Owen Banerjee?
Well, his junior was supposed to be here.
I'll keep a few small cards, send out invitations for.
Well, naturally, my lord, one appearance does not complete the day's remuneration for every year.
If you say that, Mr. Banerjee, how do I dispose of matters?
Well, we shall try. Well,
No, you will have to do more than just try.
Well, for the government side, it is very dangerous, very challenging. I will not say other harsh words.
People are suffering. That's why they are here. Yes, tell me.
Well, over here, we originally came forward with your lordship on the ground that some two vexatious complaints by some lady teachers were filed after.
Mr. Bhattacharya, those complaints have now been dismissed.
Vexatious.
So
there is no other bar, Milord. It should be released.
Should be.
Now, due to pendency of this writ application, the DI is not releasing the pension and my
So
gratuity.
Should I dismiss the writ petition? Should I dismiss the writ petition?
Well, allow.
You're saying the pendency, so let me dismiss that. DI will pay it.
Malad, only Malad, the writ application, another prayer is that we are entitled to interest. Area interest due to non-payment.
That will not count because of the pending complaint. Only after that has been disposed of.
Malad, over
when?
here.
Disposed of when the complaint?
Malad, it has been disposed
January
of
26.
Malad,
January 26.
Malad, that disposal is nothing to do with my release of my.
No, but that was the ground. They said.
Malad, but it was done with some malified intention. Just
then, Mr. Banerjee, let them file affidavits. We'll decide that.
With regard to my release of my pensionary benefits, kindly give me that. Kindly allow, and the interest part, let them file affidavit. Or your lordship, give me the liberty to raise the question of interest, because interest. Give me the liberty that
the petitioner is aggrieved that the retirement and pensionary benefits payable to him has not been paid, solely on the ground of an irrelevant complaint made by some other teachers in the school or college.
School.
Stop. As it
kindly
now
take the supplementary affidavit that will help your lordship.
Where's the supplementary affidavit? Oh, this one, the one you filed today.
Very small.
As disclosed by the petitioner in the supplementary affidavit today, filed today, which is kept on record, comma, it appears that the said complaint has now been dismissed, has now been rejected. Stop. Next, thus, comma, there is no impediment for disbursing the pensionary and retirement benefits to the petitioner in accordance with law. Stop. Next, the respondent number 2 is directed to immediately release and disburse the pensionary and retirement benefits of the petitioner by April 20th, 2026. Stop. Stop. Before disbursal, comma, the respondent number 2 will also consider the fact that the petitioner retired on
31st
December 31st, 2024,
31st December,
and has been without pension and retirement benefits till now, comma, solely on the ground of a complaint made by certain teachers of the school. Stop. Thus, comma, the petitioner may be entitled to some interest on the pensionary benefits, comma, which will be considered by the DI, by the respondent number 2, prior to releasing the benefits by April 20th, 2026. With the aforestated directions, the writ petition is disposed of. No order as to cause. Acha, upore affidavit of service has filed be kept on record.
Grateful.
44 টা ডাকো হ্যাঁ আছে Mr. Bihani is there. Yes, Mr. Bihani. Send out invites now.
No.
Invitation cards. Please appear in my court.
Well, normally.
I don't want to hear normally. Normally, abnormally.
Hear me once. Normally. Excellent.
Responding to the complaint was not
Yes, passed over. You wait.
But normally.
No, you wait. Mr. Bari is waiting. Can't chat with you.
Normally, I'm aware that the
Mr. Bari, he's wasting my time. Please throw him out.
I'm aware that the matter is appearing. I'm not ready. This time, not even I'm aware of both.
No, you want to do it today or what? Don't want to do it today. Why?
But I have to. I'll tell you, Lordship. The council briefing is out of station. I need to sit with him once.
Next Tuesday?
Any day.
No, pension matters only on Tuesdays. They get some. Next Tuesday.
I'm deeply there.
Yes.
But I did not waste your Lordship's time.
3 minutes you've wasted.
Kindly excuse me for that.
No, that's all.
Page
Yes.
Page 40
Yes.
is the objection raised by the school authority in terms of the direction.
Yes.
What has happened, I tell you a short fact. Thereafter, your lordships can go through.
Yes.
একটা বলেছেন স্কুল অথরিটি প্রেজেন্স দরকার
না দরকার নেই কিছু
in this matter the presence of the school authority required
not required at all.
Let me hear, Mr. Bari.
In the law, I am satisfying your lordships. But the rule says, if I am an untrained teacher appointed today, I have to get myself trained within a period of 5 years.
5? I thought it was
Within
2
a period
years.
of 5 years. This is the proper rule says. Suppose, Mala, in 2025 January.
I've understood. 5 years means what?
But if I do not complete, Mala, in these 5 years, I will be enjoying the incremental benefit year-to-year basis up to 2005. If I do not complete, then, my lord, the incremental benefit will be reduced.
The what benefit?
The incremental benefit will not be given. After 10 years, I will be entitled. What has happened? These teachers, my lord, this particular the petitioner is the organizing staff of his schools. By virtue of the judgment of the court, he got approval from the year 2000. That judgment was delivered in the year of 2006. To show before my approval, there was no occasion to get myself trained.
So the 5 years passed.
No, 5 years passed. Then I was not a teacher's approved teachers. The training qualifications, I have to require the training qualifications after my approval, not before that. If I am organizing teachers, that means, well, I am unapproved teachers. Approval comes after the course order or the authority gives
So
approval.
you are saying 5 years from 2006.
For 2006.
That is your point.
Yes,
And they will
because the
say from
judgment-
2000 it has to be 2005.
Because the judgment was delivered in the year of 2006. Thereafter, in the year of
So
2006.
your 2000 to 2006 or 5, what would be the nature of your service?
Malab, that has been approved with retrospective effect.
So if it is retrospective, so if it is with retrospective effect,
But I cannot complete my training qualifications unless approval is accorded. So, my lord, I am telling you, lordships, in 2006, the district inspector schools accord approval with effect from 2000. From 2006, before 2006, there was no scope to get myself trained because unless it is approved, I will not be treated as a deputed candidate. So one of the teachers, same thing happened. I had an occasion to move before the coordinate bench, placing all these facts, and same approval, my name was also included. That judgment has been delivered.
May I get a copy?
Yes.
yes, yes, of course.
There are 7 onwards. Yes. There are 7 onwards if your lordship can leave.
But from 6 to 11, you got your training.
Yes, I did it in 2008.
Yes, Mr.
Memo,
There's,
page 26 was
there's no reason to differ,
Yes,
take a
yes,
different
sir.
view.
26 was under considerations. 26
I have
same
to take
approval.
instruction whether any appeal has been preferred because
No, I complied with them.
fine,
Compliance
let me, because first time it is because the my instruction is deferred. Now, my lord, the rule says, my lord, within 5 years he has to. Now, one of the coordinator passed this order. Now, my lord, this, my lord, then my lord, I required to file an affidavit, short affidavit stating my otherwise, what will
In my
happen?
court, it works a little differently. Affidavit, report.
And my lord,
now
he received all benefits.
Now, if your lordship
I moved it.
I'll give you a day's time. You take
another
instructions.
thing, a day's time, my lord, for kindly, because there are 3 petitions in this petition. He has to pay the court fees.
He'll pay. You're exhausting your best points. Your fantastic points you're exhausting.
Kindly give me, my lord, till next week because, my lord, this order. আপনি তো স্কুলের সব আমি জানি
I have taken it. That was my client.
আপাতত আমি সব।
Next Monday.
Next Tuesday. Remind me, Mr.
And then my lord, keep it on Monday because next Tuesday.
Pension matters are taken up on Tuesdays.
To be mentioned, it can be because the lords have heard the matter.
No, I've heard the matter.
Only instruction.
No, but Tuesday are in some difficulty.
Tuesday, my lord, the circuit bench I may not be available here.
দুটো একসঙ্গে হয় বলো
না সেজন্য or this week your lordships kindly keep it. Only
I told him a day he wants to come back next. Monday to be mentioned করে দিন।
Yes.
Monday to be mentioned. Huh?
Order.
Amount of signatures you have to affix.
Yes.
Yes.
হ্যাঁ বিশেষ দিন এখনই দিন না
হবে না রেকর্ড করতে
না স্কুলের স্যার
দরকার
ঠিক না অত ছুটে ছুটে এলাম
Yes. Yes, served. Service completed. What is appearing? Yes, tell me.
After 23 years of service, petitioner opted for voluntary retirement. And the managing committee of the school in its meeting accepted that and issued released order. Petitioner then approached the school authority to take necessary steps for pensionary benefits. But since then, since my lord, September 2024, I am waiting for my pensionary and other benefits. Though my lord, the GPF has been issued.
Issued.
GPF has been released. General Provident Fund money has been released in my favor.
No, so that means they have acted in terms of the.
One later I am trying to show your lordship, subject to your lordship's sanction, my lord.
Yes.
But page 30. And it's at P11. If your lordship
Yes.
take trouble to look into this. But here, the school authority wrote me a letter. I repeated, due to my repeated approach, they told me that we have informed by the district inspector office that the reply may not be come because the DI has approached the commissioner. Unless and until they get the reply for the commissioner, they will not take any step. They will not intimate me anything, and they are not.
Come to the fifth line. For some reason, the office of the. Forget the letter. Come to the fifth line, page 30. For some reason, the office of DI could not proceed with your pension work. What is this some reason?
Then, my lord, then information regards VRS was sent to the Commissioner of School Education, Vikas Bhavan, on 26 June 2025. Again, your pension file was sent to the district inspector of school few times, but each time it was returned. The reason given by the district school office is to wait for the reply from the Commissioner of School Education regarding our letter. But in this transit, I am waiting.
Why? What happened to your Section 6 application?
Nothing, no information.
No
was
reply.
given. And then page 36, under my last approach.
36, yes. Yes.
I approached to the district inspector of schools again.
No, but DI is saying unless commissioner
grants permission, I will not in a position. But in the month of September 2024, everything was done.
The petitioner has retired from service sometime. No, petitioner has taken voluntary retirement from service and has retired sometime in the year 2024. Stop. They said retirement of the petitioner was duly acceded by the managing committee, release order issued, and all consequential steps taken. Stop. Next. In spite of the aforestated, the petitioner has not been paid any pensionary or retirement benefits on a rather flimsy pretext, as will appear from the letter of 8 September 2025, that the Commissioner of School Education has not given a reply to the letter, to the respondent number.
TI is one respondent number 4.
4. Stop. Next. In view of the aforestated, the petitioner is without pension since 2024. Stop. Next. Should I pass a direction or should you serve once more on the office of the GP?
It will be better because there will be a specific order. Because
in view of the aforestated, the petitioner is directed to effect a notice on the office of the government pleader, intimating him that the matter will appear in the list on April 7, 2026. Stop. List accordingly. So, put affidavit of service as filed. Tarpore, in spite of service, none appears for any of the parties. Yes.
This is the affidavit of service. I served all the respondent.
Yes.
The case of the
You are
petitioner.
appearing, madam.
The case of the petitioner is that, my lord, the petitioner is a retired teacher, my lord. Before retirement, at the verge of retirement, the authority asked me to deposit some amount as a overdraw.
You have deposited.
I have deposited. Until and unless I have deposited the said amount, the pensionary benefit has not been given. Under compulsion, my lord, I deposited the entire amount they asked for by treasury challan. my lord, the settled principle of, my lord, at the verge of retirement, my lord, since the petitioner has no fault for receiving the benefit, service benefits, my lord, the approval has given by the, my lord, authority concerned at the time of retirement, my lord, the Rafiq Moses case says that, my lord, they are at the verge of retirement, they cannot do it. So what I am paying before your lordship, let this amount be refunded to the petitioner along with interest. My lord, my
Show me the
Treasury channel, my lord, page 20. Annexure P2.
You retired on?
I retired, my lord, 30th November 2025.
Yes.
And PPO has been issued, my lord. Next page, page 21. The date of retirement, my lord, 30th November 2025.
Yes. Yes, madam. Next Tuesday, but you come back with, if you don't, I'll just, you have to refund the money.
Yes. It's a settled principle of law.
Look up, 2015, 3 SCC, 339. Look up. There's a decision of Justice Tandon as well, I think.
Yes, my lord, and
Special bench.
all, my lord, the judges, my lord, followed that judgment and passed the order.
Yes, yes.
And next day, my lord, I also produced the several orders passed by this court. Next day, I will produce this.
Yes. Next Tuesday.
I appear for the state respondent.
29th. April 28, sorry, not 20, 28, 28 April. ওই মঙ্গলবারটা দেখে দিয়ে দেবেন 28 April.
49, not today.
Prayed for adjournment.
Lord, I beg to appear for the petitioner. Lord, the petitioner herein is praying for issuance of a fresh PPO.
Use the microphone.
I'm using it.
My lord,
the petitioner herein is praying for
Mr. Orunava Mitra is appearing for the state. He is engaged.
Who is appearing?
Orunava Mitra. He is engaged in another court. My lord, I am praying for not today.
Next Tuesday. Respondent chaile next Tuesday. Petitioner chaile 28th. Yes.
3,97,199. Kindly see my lord PPO.
Yes.
My lord, gratuity amount 4,91,865. Net DCRG, my lord.
Where are you reading?
1,666.
Where are you?
Deducted, my lord.
Where are you reading? You have to. Where are you reading?
And see my PPO, my lord.
PPO is a whole document. Tell me which part, sir. Just don't open it and start reading it for your own joy, na?
6, my lord.
Say that. Serial number 6.
Serial number 6, 7, my lord.
Yes.
Gross DCRG 4,91,865.
Yes.
Well, after deducted the overdraw, my lord, 3,97,199.
Net DRG is 94,666.
Yes, my lord.
This is what you've been paid.
Yes, my lord. This is my prayer, my lord.
Deduction is 397,199.
Yes, my lord.
Yes. Why is the deduction being made? What is the ground?
Calculation, my lord. Wrong calculation, my lord, on the basis.
Wrong calculation. Show me from the, when your pleadings have you said that?
My lord, kindly see my lord, lordship's order by the way of treasury challan might be.
Are Baba, you show me from your pleadings, na? Show me from the pleadings where it is.
Kindly, my lord, page 5, my lord.
Yes.
Para 8, my lord.
Yes.
It is stated that pursuant to the said PPO, the petitioner was entitled to
Yes.
some of
Yes. Now show me the order. Yes, sir. You've seen this. You've seen the petition. Not received instruction.
Parallel order, same order.
Malad, this order is malad way of treasury chalan. My petition, my prayer is malad deducted by the gratuity amount.
From the gratuity amount.
From the gratuity amount.
Now just you correct the order.
Yes.
Give the right dates.
31st March 2012, my lord. Date of retirement.
31st March.
2012.
Yes. Amount?
Deducted by my lord.
No, deposited. How much do you deposit?
3,97,199.
Yes. Not by the treasury challan, by way of?
By way of gratuity amount.
You are required to deposit this by way of?
Deducted, my lord.
You deposited. First you had to deposit. On what?
No, my lord, not deposited. Authority concern already deducted.
এই মোটামুটি এই অর্ডারটাই হবে, জাস্ট কয়েকটা জায়গা আমি এই করে দিচ্ছি, রাইডার হিসেবে দিয়ে দেবো। হ্যাঁ, রাইডার 1, রাইডার 1 হবে the petitioner received his pensionary retiral and pensionary benefits of rupees 94,666 after deduction of rupees 3,97,199. না হলো না, এটা থাক, এটা সেকেন্ড লাইন হিসেবে যাবে। এই ফার্স্ট লাইনটা হবে the petitioner was entitled to a total sum of rupees 4,91,865 on account of pensionary and retiral benefits. Stop. However, তারপরে the petitioner received যেটা আছে, তারপরে যেরকম আছে থাকবে, অসুবিধা নেই। You received in, when did you receive?
Hello?
When did you receive the money? When was the payment made to you? 94, when was it made to you?
13th June 2014, my lord.
2014? Huh?
12, my lord, retired. PPO is to my lord 14.
So what stopped you from approaching court?
I don't want to see that same judgment. Same judgment, my lord.
What same judgment? What stopped you from coming to court earlier? You've come in 2024 after 10 years. Why?
12 years, 2 years, my lord.
How?
31st March 2012, he retired.
Yes.
PPO issued on 13 June 2014.
Yes.
PPO issue.
So PPO issued, and when was the payment made? After the PPO is issued in 2014. So 2014.
2014. Deducted.
When did you receive the payment? আরে টাকাটা কবে দিল আপনাকে? কি মুশকিল রে বাবা, কি বলবো বলতো।
মানে 13 June 2014, my lord.
2014? Why did you wait for 10 years before coming to court? You petition as of 2024. বুঝতে পারছেন না নাকি কি বলছি? বুঝতে ঠিকই পেরেছেন। 10 বছর কেন ওয়েট করলেন? না না, you won't get the interest. No interest.
Same judgment.
No. Where? What same judgment?
People living remote village.
Well, I have become cleverer, so can't be helped. What steps did you take? Did you take any steps between 14 to 24 for realization of that amount? কথাই বুঝতেই পারছি না কি বলছি।
দেওয়ার জন্য কি আপনি আর কোনো রিপ্রেজেন্টেশন বা কিছু করেছিলেন সেটা জিজ্ঞাসা করছিলেন? বছর আপনি ওয়েট করলেন কেন কোর্টে আসার জন্য সেটা জজ সাহেব জিজ্ঞাসা করছে, আর এর মাঝে যদি কোনো স্টেপ নিয়ে থাকেন তাহলে সেটা বলে দিন।
No step.
No step, yes. From the date of filing of the writ petition করলো এখানে from the date of issuance of pension payment order না করে from the date of filing of the, এটা আমি লিখে দিলাম, একটা লাইন ওখানে জাস্ট ঢুকবে প্যারাগ্রাফ 4 আর 5 এর মাঝখানে, the petitioner had received payment pursuant to the pension payment order bracket PPO in June 2014. Stop. However, the petitioner had not taken any steps between 2014 till 2024 when this writ petition was filed. Stop. The petitioner is disentitled to seek any interest for the period from 2014 till 24. Stop. However, he will be entitled to interest from the date of filing of the writ petition till receipt thereof. দিয়ে তারপরে এখানে যেটা করছি এটা রাইটেড 4 and 5 এর মাঝখানে ঢুকে যাবে as রাইটেড টু 8% interest from the date of filing of the writ petition. No, it's not that easy. He was thinking from the date of PPO, which is what I had given in the earlier matter. Yes.
Carefully.
At least make out a case in the petition. 14 to 24, I had a headache, stomach ache, so I couldn't do anything. In the next matter, when you file, make out a case. 10 years had an explanation কিছু ঢোকাবেন petition এ। মাথা ব্যথা করছিল 10 বছর ধরে, তাই করতে পারিনি। Yes.
My lord.
And I'm appearing for the state.
What?
Same matter. Same.
করে দাও 28.
28, my lord. I'm grateful.
At 28, she better come. It will only be her matters in the list. Yes.
53, but I'm appealing on behalf of the petitioner.
Yes, Mr. Vanda. Nobody's opposing you. Stop. Nobody's opposing you.
Well, I have, sir.
Yes.
Writ petition pertains to only to revise the pension payment order after refunding the amount of overdrawal pursuant to the order passed by this honorable court.
That has been
Yes.
refunded.
But the last basic pay, which was reduced and the overdrawal was not occurred, that has not been recast further. This is only prayer. Because petitioners retired 2023.
Yes.
After retirement, authority detected that the basic pay payment was made more than which he was entitled. That's why overdrawal was calculated, reducing the basic pay of last basic pay. By the petitioner approached before this honorable court, and my lord
Directed to repay. Refund the overdrawal. Then?
But my lord, the refixation which could have been my lord made by the authority after refunding.
That should have been made. Otherwise, the refund becomes.
Yes. That part has not been done. Only this is only prayer. Malada, there is a settled proposition of law.
আরে বাবা, other side কে ধরে আনতে হবে। Settled proposition হলো পরে হবে।
যদি না আসে কি করব?
Who have you served? GP of
state and everybody.
Mr. Mitro, পিছনে লুকিয়ে বসে আছে। Appear in this man.
Yes, he's a.
And he was hiding there. He saw I was looking at him. Quietly hid there.
Refixation.
Overdrawal.
Overdrawal has been allowed.
May I বলে দিই ব্যাপারটা? So far, my lord, Rafiq Musi is concerned, it never tells about refixation.
No, correct. Rafiq Masi is only on the issue of refund of.
It is wrongly done or rightly done at the verge of the retirement within 1 year or after.
Correct.
It has to be refunded.
No, but that has
So
already.
petitioner got refunded.
He has been refunded.
Now he has to make out a case that he is entitled legally that particular scale. My lord, in our petitions, general usual cases, that is why, my lord, consciously we not make that prayer in most of the petitions. But here petitioner is, if entitled to get, he will get. But that is a different case. That
No,
is
but then who will consider this?
of course, DI, my lord. He is the
Should I pass a
sanctioning
direction
authority.
on the DI?
My lord.
Yes.
Huh?
Because of all the pension sanctioning authority is DI.
DI is the pension sanctioning
He
authority.
should have been recast.
Recasted.
No. Based on the Honorable Division Bench, upheld by the single bench judgment, paragraph 5 in the division bench. Hare Krishna, Maiti, and following the division bench, the single bench also, the paragraph 9.
It's not automated. It's not automated.
Paragraph 5. Eighter second paragraph.
লিখে দে কোনটা কোনটা কি করলি একটু দিয়ে দে জানি
Single bench judgment was upheld by division bench, and this is the following the division bench, single bench has passed an order. Paragraph 9.
I thought you were no. 8 and the other one at 245.
This is division bench.
This is another matter where I had appeared before Justice Banerjee.
249. I believe so. The division bench
249.
Yes. Division bench.
Division bench. Yes. Right. No, this is Mr. Panda. This is only on the issue of refund.
No, refixation also.
Where?
Well, can you see? Paragraph 9 for
10,
the above region. I
10.
Yes, direct the pension provident fund insurance here we direct to refix the amount of monthly pension.
আর তাই তো বলছি paragraph 10 9 করে যাচ্ছে.
I mean 9 and 10 both. I have start for 9.
Then let me direct the DI to consider the same.
Consider taking into decision of the honorable division bench and
both.
Yes.
Just Mr. Panda, just give me the date of the order of refund.
Refund. Refund is page 42.
Tell me the date now.
Date of order of the 7th March 2024.
The petitioner has agreed that in spite of the refund, made by the concerned department pursuant to the order of this honorable court dated March 7, 2024, his monthly pension, his basic pay and monthly pension have not yet been refixed. Stop.
Refixed. About the receipt on the last pay drawn by the petitioner.
Stop. Next. I direct the respondent number, DIS.
Respondent number 4.
To refix the pay, refix the basic salary, basic pay and the monthly pension payable to the writ petitioner on the basis of his last drawn pay and consequential orders may be passed. Consequential orders are to be passed by the respondent number 3. I direct the respondent number. No, 3.
3 is the PPO is after the pension sanctioning authority.
Respondent number 4.
Respondent number 4 is the pension sanctioning authority.
Yes.
After recast, the DPPG will be the issuance of the authority for.
Yes. Four. Stop. Next, I make it clear that the respondent number 3, DI.
Yes. Respondent number 4 DI.
Respondent number 4 will
Consider in terms of the division.
complete the entire exercise in the light of the decisions of this honorable court reported in 2010 bracket 2 Calcutta Law Journal page 241 as upheld in the decision reported in 2009.
This is prior to that.
Huh?
Division bench is
হ্যাঁ।
prior to following the division bench single bench.
তাহলে ওটা কি বললাম 2009 2 CLJ
Division fourth.
পেজ কথা বলেছিলাম
এটা অ্যাপিলই হয়, it has been complied with.
আগে division bench হয়ে যায়।
না 9 2 CLJ 259 Calcutta Law Journal 259 and 2010 2 CLJ page 241. Once the respondent number 4 takes the appropriate decision, comma, the respondent number 3 will act in accordance with the same and issue the fresh pension payment order in favor of the petitioner. Next, with the aforestated directions that the petition is disposed of, there shall be no interest costs. Entire exercise will be completed কতদিনে বললাম? এটা এই হয়ে গেল। The entire exercise undertaken by the respondent number 4 will be completed by May 31st, 2026.
My name.
Sorry, sir. Since একদম উপরে affidavit of services filed is kept on record, stop. Next, in spite of service, none appears for the authorities. Stop. Mr. Mitro, who usually appears for the state, is present in court and is requested to take up the matter. Stop. Let his appointment in this matter be regularized. Yes.
Division. Well, I shall make a photocopy of the division bench, then I said single bench I am giving malu. Single se didi.
Generally, my lord, in the overdrawn cases, we have only asked for refixes to
Only
the
for-
amount.
Yes.
You have that. But this is exceptional. Here, my lord,
Here the basic pay also be
basic
paid.
pay. Great.
ওটা আমি জেরক্স করে দিচ্ছি ডিভিশন বেঞ্চটা।
Yes, you just give it, Mr. Panda, you give it. With division bench এটা দিয়ে যাবে। তা নিয়ে নিন। Yes.
I'm for the petitioner.
Yes.
What all matter? Matter retired on 30 April 2022.
Hey, Arindam.
Amount.
Just.
What is the overall matter? Matter retired on 31st April 2022.
Yes.
Is refund the money on 20th January 2022. Already matter passed the order, man. Already matter passed the same order.
I've seen the order.
Instruction has not been received, my lord. Instruction has not been received, my lord.
No, I will just direct that excess amount to be repaid. The overdrawn amount which you have deducted will be repaid. Yes, you have made the necessary corrections though.
Yes, ma'am.
Yes, your name? What is your name? You have not, Mr. Maiti, you have not corrected his name. Huh?
My mistake.
Give your name, give your name. Yes.
I'm for the petitioner.
Yes.
It's a case, my lord.
Sort of,
Petitioner is the widow of the deceased.
54 ওই অর্ডারটা
Now, my lord, your lordship knows in Obijit Doito in 2014,
Yes.
my lord, an order was passed to conversion from CPF to GPF by the employee concerned. It was the understanding of the state that only the petitioner who are working as a teacher, he or she can only give the amount back and get the pension benefit. Now in 2023, one of our division bench first decided after on appeal that no, the widow can also, my lord, refund the amount. My lord, thereafter, my lord, the single bench has passed orders. My lord, I have annexed it subject to your lordship.
I have just now received instruction, my lord. That my instruction is that the widow cannot entitled to get the benefit, my lord. Just paragraph 5.
No, then you argue. Your instructions have no relevance. You argue the matter. Argue the matter because the division bench has held. No? I can't go beyond the division bench's finding.
As the employee died on
Para 7, my
2013. The employee option.
Mr. Maiti, are there in this matter?
No, my lord, he's junior. I am leading.
So why haven't you given your name? Yes, sir. Tell me.
Well, as per my instruction,
your instruction is irrelevant. Either you argue the matter, or I pass this order. You see the division bench order. You see the Mr. Mitra, give him a give him a copy of the division bench order. You want to come back next Tuesday?
I copy Obijit Doito.
Yes.
He knows.
Kindly record my instruction, my lord. That's all.
No, then I have to decide.
You have to say, kindly record my.
No. Make your submission. Make your submissions.
As per instruction, he is
No, not as per instruction. Make your submissions. Why? You can't just throw an instruction at court and say record it. No, I won't. I will not record. It's your instruction. Keep it in your pocket. Argue the matter. I'll record every submission that you make. But you have to make the submission.
Just now I have received instruction. Today I
pray for time. Pray for time. I will not record it. I will not record. The DI and the authority is not my concern. You are. Make your submissions. What your client is instructing you, why should I record in my order? Come back next Tuesday. Get ready, come back. Hey, make up your mind, sir. What? I'm not going to record your that No. You show me the law. You show me the law that you have a right to have that instruction recorded. You show me, I'll give it. I'll give you a provision by which I'm not even supposed to look at it. I'll give you a provision. You argue. I'm not closing my mind. You argue, I'll hear you happily. You come back on next Tuesday. I'm not going to embarrass you. You come back next Tuesday. If you feel that there's something which requires attention, you argue that point. I'll hear you.
Yes.
Let him come back. Yes. Mr. Mitra, I'm retaining a copy of that order.
Yes. Thank you.
No. Order to retain করুন. Order. হ্যাঁ, sir.
দিলাম আপনাকে এই তো।
না, এটা এখানেই থাক, ফাইলের মধ্যেই থাক। Yes.
Grateful.
I have the leave to mention my.
This is not the mentioning time. You can't just come and mention and take the mic whenever you feel.
Not for that, sir. Since today is a resolution, just now I came to know at 3:30, but my matter is already listed at 4 o'clock today.
কি করব আমি এবার? কি করব আমি? You tell me, sir, what am I supposed to do? You tell me. I'm here. You get your other side, I'll take it up. That's the best I can do for you.
Sir, grateful, sir.
কি বলবো বলতো? ওর কালকে থেকে পরীক্ষা, 7 তারিখ থেকে পরীক্ষা, আমি মানে 3:30 আসবেই না।
disciplinary petition.
56, I'm for the state, Your Lordship. I need some time to.
Next Tuesday.
Instruction. Great.
57 out of the
Yes.
petitioner. The issue in respect to the petitioner's case is now res intriga. By passing a division bench order, following the division bench or single bench, coordinate bench, passed an order, and it has been complied with. The case is petitioner is the one of the initially.
Then it's res judicata, not res integra. It's no more res integra.
Yes.
It's been decided once and for all.
Yes. Allowed.
Ajay, first tell me what is the issue then?
The issue, the petitioner initially was the CPF scheme. The Lordship knows, my lord, in terms of Abhijit Boiddo's decisions, everybody has, my lord.
That's CPF to GPF.
Petitioner could not.
So Dashgupta.
Yeah, he knows that. May I, my lord, once one order passed by the coordinate bench,
yes.
I have, my lord, corrected the.
Yes, I always prefer that. I always prefer that. You haven't given Mr. Dashgupta's name.
Yes.
You haven't given his name. What? Yes.
Second paragraph I deleted because I did not make any representation. Employee. Sorry, I mean.
No, and Abhijit Boiddo is reported in?
Yes, my lord, Abhijit Boiddo.
Abhijit Boiddo is the lead now. Abhijit Boiddo decided this issue.
Yes, first. Then, my lord, the Muktimoyi Pal.
No, you tell me because Abhijit Boiddo has to be referred.
Yes, Abhijit was also referred here.
No, it's not referred.
In the Muktimoyi Pal, Abhijit Boiddo.
I want to refer to Abhijit Boiddo.
Yes, Lordship can see. 2013, volume 3. এটা দিই না আরেকটা হ্যাঁ আরেকটা আছে যেটা সুনীল কুমার গোটাই
কত 2013 volume 3 না সৌরভ writer A করে নাও the petitioner has placed reliance on the issue is no more res integra. The issue is no more res integra as the issue has been conclusively decided by a division bench of this honorable court, reported in decision whereof has been reported in 2013 bracket 3 CHN page 714 and also in MAT 146 of 2019 bracket State of West Bengal and others versus Muktimoyi Pal bracket they and others. This is Purva Mednipur.
Yes, in the Paschim Mednipur.
Not corrected anything.
I have not corrected. Yes. Oh.
Is it what? PE or SE?
Not AC.
Which is the correct one?
I have not. I have given a corrected copy. কি করেছো? সবই আমি দেবো। I'm sorry, Malad. I apologize. এইখানে করেছি। ঠিক আছে? বাস, আবার একই।
What? When have you retired?
I have retired about 2000.
This line, the pension shall be paid to the petitioner on and from the next date of superannuation means what?
From the date of retirement.
Next date
But next date, I retired 31st.
from the day after. But you have already retired.
Yes.
So it will be from the back day.
Because I am not getting pension.
From the date.
Next date of superannuation.
From the day after the date of superannuation. But they cannot show this.
Justice Mantha has taken into the Abhijit Vaidya's case.
Mukti Mohi or whatever that is.
Both. Abhijit Vaidya and Mukti Mohipal. Justice
Sinha has only referred to.
But because of Mukti Mohipal is the initial judgment is Justice Sinha. That was appealed by division.
I see.
I have both the copy. I have. If Lordship has
Justice Sinha hold that since the time is over, he cannot.
I see.
The appeal court will reverse down.
So you saying appeal?
No, appeal.
So you go out and
Justice Sinha has
go out and fight because my day is not over yet, unlike yours. Yes. Mr. Bihani, কোথায় গেল? Yes, tell us, what do we do out here? What do we do, Mr. Bihani?
I do not know. I have my instruction is to oppose it.
To oppose what?
Prayer.
Prayer for?
His prayer is, in short, his prayer devoid of the illegalities being alleged. His prayer is that he ought to have been admitted in view of his revised marks in the LLM course. Now, after his admission,
no, you've given the affidavit.
Yes, within time.
So even I filed the affidavit reply.
You filed.
I also filed.
Affidavit.
No, out of turn I'm taking. So when is your exam starting?
Sir, the day after tomorrow, and I'm having only tomorrow to complete the admission formalities and the.
Yes. Yes, very in a nutshell, as short as you can.
Sure. So kindly come to my affidavit in reply.
You have to start with your affidavit in reply. There's nothing in your petition. Yes, start. Hurry up.
Because the affidavit in opposition they have filed.
Doesn't matter. You tell me your case first.
I'm telling my case only, sir. I am telling my case. I have raised a preliminary objection in my affidavit in reply. As to that, the affidavit in opposition has been found by one trust officer of the university.
All these are nonsensical points. Come to the merit of the matter.
Sir, he is not having any authorization.
Come to the merit of the matter.
Sir, come to page 5 of my affidavit in reply. No, they have contended that there was no procedural opacity in relation to the phase 1 counseling process. But I am saying there is procedural opacity. Why? Because the notification dated 24/9/2025, as mentioned in their affidavit in opposition and also in my affidavit in reply, and it is also mentioned in the original writ petition. They might have issued that notice, but they have not uploaded in the designated web page that is given on page 5, that is www.barunip.ac.in/pg admission/index_pg.php. Now, sir, kindly come to my annexure 5 of the writ petition at page 44. This is the screenshot taken by me of that designated web page of the university, wherein all the admission related matters.
Please start your matter from the start, the beginning, ABCD. Yeah? Don't start. You're starting in the middle. What are your points? You're an unsuccessful candidate for LLM.
Sir, the point is that, first of all, my grievance was that my review application form of the second semester LLB that was submitted by me on the 25th of April 2025 upon a notification of the constituent college on dated 24th of April 2025, the application was not forwarded to the university. That is, this fact I came to know only upon receipt and perusal of the affidavit in opposition, not prior to that. Because why I'm saying not prior to that, when I made a representation to the controller of examinations on 6th of December 2025, that is my annexure P11. Yes, P11 annexure. The reply that was sent by the controller of examinations on 17th of December, that is annexed at page of the same annexure, the last page of the annexure, page 83.
Sir,
Lordship, if
we are short on time, so please make a concise submission.
I'm making a concise only, sir. Kindly allow me this much, Your Lordship. Kindly come to refer point number 2 of the reply. They are saying, after publication of review results of any course and batch of students, there is no scope to accept the form of any other candidate and repeat the review process. Only this much information was given with respect to my Pardon?
What are you referring to?
Sir, Your Lordship, page number 83 of the writ petition.
Yes.
Kindly refer to point 2 of the reply. After publication of review results of any course and batch of students, there is no scope to accept the form of any other candidate and repeat the review process. Now, apart from this much information, no other cause was given, and the same cause was given only through this.
For what?
Cause.
For what?
For not processing my application, LLB.
Where is your letter saying that? Where is that letter of yours asking for review or whatever?
A review application form?
It must
At
have
page
been
77.
So it must have been after the review results had been published.
So that fact has only been said or disclosed only on this affidavit in opposition, because the notification what we received from our constituent college, I have annexed that WhatsApp page also in my affidavit in reply. Your Lordship, then I'll take you to affidavit in reply, page number 37 of my affidavit in reply, page 37.
Yes.
So kindly come to see the notification, that is doc scanner 24th April 2025, 12:28 p.m. And that notice is on the page 36. That's on the previous page, just on the previous page.
Yes.
This acting on the basis of this notification, I have filed it on 25th, the very next day. Because though it was told there that the 26th was the day, but if you see the page 37, another message, due to Shakuntala Kali Puja, there is a slight change in your review date. You have to come tomorrow at 11:30 to 1:30 p.m. positively. Otherwise, we can't take your review application.
Yes.
So for that, I have filed the same on 25th. And my review application, your lordship, again, I'll take your lordship to the writ petition at page 77, and my and the amount of the review fees that is directly paid to the designated university account, that is lying at page 79, that your lordship can refer from page 79 and 82 pages receipt. It's a screenshot taken. Hence, since I have made the payment directly in the university account, the university is vicariously liable to ensure the coordination, transmission of the form that was submitted to its constituent college, because the constituent college is operating under the guidance and instructions of the university, not as per me. This is my first grievance, your lordship. Second grievance, that I filed the LLM admission form on 9th of September.
Yes.
And the notification, as per acting on the notification of the 6th semester review application.
Sorry, just give me the date, 9th of
September.
Yes.
To 2025. And acting on the notification of the constituent college based on the original notification of the university, the 6th semester review application form was submitted on 11th of September. Thereafter, this review of this review results, review gazette of this
11th September, you submitted review for the 6th semester.
6th semester.
Yes.
And the review gazette of the 6th semester was published on 24th of November, when almost the LLM admission procedure has closed. Not closed, it is ended on 20. It has actually ended on 26th, but I could not. Why I'm saying this? Because when my 6th semester results were published, I saw that my marks have been upgraded. But I'll take your lordship to page 4 of my writ petition. Page 4 of my writ petition, just the paragraph, second paragraph within the inverted quotes. 20%. This was the formula that was adopted for LLM merit rank. 20% of the marks based on the marks of best 5 subjects, full marks each, 100 each, obtained in the 10th standard examination, plus 20% marks of the based on the marks of best 4 subjects obtained in the 12th standard or equivalent, plus 60% of the marks based on honors major subject only obtained in the qualifying B degree, that is the LLB CGPA. Accordingly, not accordingly or automatically, my merit rank that was formulated by me or calculated by me for the LLM course, automatically it is artificially depressed because of the 2 reasons just now iterated before this honorable court. Now, they have raised a point in their affidavit in opposition that the university has published the notification for the review of 2nd semester long back, which I came to know only after this, after perusing this affidavit on service, affidavit in opposition. Now, if this is the question, I have also submitted my 4th semester review application form on that very same day, 25th of April, 2025, which I've annexed along with my affidavit in reply at page, that is the annexure P14.
So you've asked for review of 2nd semester, 4th semester, 6th semester.
Right, sir. But that's what. But 4th semester on that. Why I am saying this before your lordship? Kindly note that date again. On same date of 25th of April 2025, I submitted my 2nd semester. That was not processed at all. And on the same date, I have submitted my 4th semester. That was processed miraculously. That was processed. And though my marks for the 4th semester remained same, no changes in the gradation, but that was processed. I have the review gazette for that. That is my point. What I'm trying to say before your lordship, I am not at fault for these procedures or these administrative acts that are only attributable to the university. And for this part, this 2nd semester part, the universities, I repeat it, the university is vicariously liable. And for this 6th semester part, the university is directly, absolutely liable. Why I'm saying this? Because when they're considering that formula that just I have showed before your lordship, then they could have completed the review process much before the LLM admission process. That is my second point. And the controller of examinations, when he had responded to my representation on 17th of December, if he could have disclosed that same reasons which he had now disclosed.
Mr. Bihani, is it possible to permit him to? No, but LLM, he has not even qualified, no?
Let him complete.
No, he will not complete. From what I can understand, he will continue till 6 o'clock.
I'll complete. Your lordship, I'll complete.
Sir, Mr. Bihani and we are both doing you a favor by sitting on.
No.
I have no vicarious liability.
I'm grateful to you for that, Lord.
So hurry up, na.
Sir, your lordship, what I want to say that is, I am deprived of my rank, merit rank, and
what do you want now?
Sir, that's what. When after the completion of the 3rd counseling, which was declared as the last and final counseling by the university, that time the counseling process was declared, but the admission process was not closed. I made a representation before the faculty council stating my grievances to consider my prayer. They kept my representation pending. Neither they had refused, neither they have accepted.
So what do you want now?
Only for that reason, I have come before this court. There are vacant seats. There are vacant seats.
What do you want now?
I want my admission to be granted.
Not happening.
Pardon, sir?
Not happening. Not happening.
But seats are vacant, sir. It will be public seats, sir. Will go waste.
There are a lot of seats vacant for judges of the High Court. That doesn't mean you come and sit on the chair.
No, that is
so you have to be qualified. Your LLM, you did not qualify. You are not qualified. You did not get admission into the LLM course.
Only for that reason I have come before this court.
So if you have not got admission, just because there are vacant seats, I ought
not because of only the vacancies. I'm also deprived. That's what I iterated before this honorable court.
Unfortunately, it's closed.
So, but my application is filed before its closure.
Maybe, but it's been closed after that.
And I have also challenged that closure.
There is a finality. It has closed. Examinations are starting.
But my representation, kindly consider this, your lordship. My representation is only before the closure date.
Maybe
that is only the point. They have not considered, and also
representation
and also
get into the habit of listening. You're studying to become a lawyer, na?
Your lordship.
So get into the habit of listening to the court.
Your lordship.
Raising your voice and sounding excited won't help you.
No, I'm not raising my voice.
So if you have not succeeded, I can't turn the clock back for you.
So
if your representation has not been considered, I can't turn it back for you. I'll empathize with you, but beyond that, I can't help you. Please understand my predicament.
So there is a provision of law, the status quo ante. And also one more thing.
When a status quo ante is passed, do you have any idea?
So I'm saying,
Give a 1 hour lecture right here, right now on a status quo ante.
no, I'm not saying, I'm not contesting against the honorable court.
Why should the status quo ante be granted in your case?
Because my representation has been filed before the.
Again, if you know what a status quo ante is, you wouldn't have said this.
And also there are other legal issues. The closure was not as per law of their own rules.
Sir, either I help you, because I'm not going to sit here till the cows come home. So either you facilitate your own case and try and find out a means and ways. Otherwise, I'll have to post it on a later
Sir,
date.
as per the Burdwan University Ordinance number 15, I am having that law.
Show me.
Sir, on ordinance number 15,
yes,
it's very clearly written there that any issues with regards to the admission and enrollment procedure must be decided by the Secretary Faculty Council in consultation with the departmental head.
Yes.
But in this case, for the closure and for non-consideration of my candidature or my representation, no deliberation or no meeting was convened.
How do I know? You'll have to prove all that, na? Mr. Bihani.
Because they have said in their affidavit in opposition.
And I tell your lordship, my lord, it has just now fallen from your lordship, but I have gone through the details. I spoke to my authorities that your lordship is empathizing. My lord, I submit with your lordship, he has no merit, no legal right at all. I'll just take 2-3 minutes. But I've said it in the affidavit. I tell your lordship the facts.
See, if I have understood him correctly, he's saying, had my review applications been considered?
That is not correct.
Are Baba, you're just
I
giving,
understood.
no, you couldn't have understood what I have understood.
True.
I'm telling you what I have understood from his submission. Might not be at par with you, so please have some patience. My understanding of his submissions is this, that there are multiple review applications which he's made.
Correct.
Some of them were considered, some of them have not been considered. Those which have not been considered have, the resultant effect is his rank has gone down. And therefore, he became, well, in a way, ineligible to qualify for the LLM examination. This is how it stands as of now.
Correct.
Am I correct? So now you tell me, yes, is there a way out? Can we resolve this issue?
May I reply to that first?
Yes.
Now, my lord, I'll not trouble your lordship. I know lordship position right now with time. Only takes 2 pages of my affidavit in opposition.
No, also this ordinance 15, what he's saying.
I'll come to that. Kindly takes page 14 once.
Yes.
Affidavit. Well, kindly sees that this is the answers review for the answer scripts in respect of 3-year LLB semesters 2 and 4.
Page 14.
Page 14 of my affidavit in opposition.
I see. Semester 2 and 4.
Lordship has seen that?
Yes.
Now kindly checks the dates.
2022.
Yeah, that's what he's applying for. His course in LLB is 2022 examination 2022.
Your lordship, the course was originally named as 2022-2024, but from the second semester onwards, there was approximately 6 months lag in every semester.
Now that kindly checks the date. Date without late fees 7th March 2024. Date with late fees 11th March 2024. The college, I've stated that the college had sent 2 review proposals to the university. I've stated the roll numbers. The review proposal of the petitioner with regard to these 2 semesters was never sent by the college to the university. Number 1.
Who's for the college?
I do not know. Already served on. That is number 1. Number 2. Now comes the second part of his ambition, that is multiple review. He has also applied for the 6th semester review. Now, my lord, kindly takes his writ petition at page 77. What page is that? Review result. I have annexed that also. Now, I am annex page number to all. I'm just giving 1 second. I'm going to give a lordship the page number. Yes, my lord, kindly it no page number to review result. Hey, kindly takes page 77.
Yes.
My lord, this is kindly his first point. 3 years LLB semester 2, semesters 2, semester 6. Semester
yes.
6 semester 2. Now, my lord, kindly sees the date at after point number 10. 25th April 2025. The last date for submission was with late fees was 11th March 2024.
Yes.
Number one. Now, the last point, my lord, by learned friend, is that if his result, that had resulted in if his rank going down, what I have stated in my affidavit kindly takes one paragraph only.
No, 77, what did you show? Semester 2, then?
Semester 2, my lordship has seen page 14 of my affidavit in opposition.
Yes.
Semester 2 and 4, the last date with late fees.
So he's giving it on 25th of April 2025.
More than a year. That is the application. And now after publishing of the results, I have stated that with regard to this, they also had applied for semester 6. His rank, his marks in the semester 6 was had increased. But how much it had increased? Kindly takes now page 9 of my affidavit, one paragraph. So semester 4, the university had not sent anybody, his candidate.
The college.
The college, I'm sorry, the college. Now semester 6, kindly take page 9, the last paragraph.
Page 9, yes.
I state that after publication of the LLB semester 6 post-publication review, change from 6.66 to 6.69, there is increase of GPA of 0.03. If this is considered for preparation, the petitioner's rank may be upgraded from 86, which was original, to 82 or 83, and the last person who has got admitted, his rank is 46. I cannot bypass that, even if the delay was condoned. So, delay, he does not stand a chance. Merit-wise, he doesn't stand a chance.
Your Lordship,
And what about Ordinance 15?
Yes, now my lord, he had made a representation to us. Now kindly takes page 83 of his writ petition.
80?
83.
Yes.
Now this is the reply to his representation. Kindly sees. Here the petitioner's name with respect to your email dated such and such,
Yes.
address to the controller. Now kindly sees the representation on the 18th November 2025. Much prior to after that. Now still we reply. What do we say? After submission of forms by the examination through their online portal, the college concerns approves the forms of the candidates who fulfill the essential eligibility criteria through online college portal only. The admit cards of the said approved candidates are generated accordingly by the concerned agency and sent to the college concerned. There is no scope of intervention by any other person. After publication of review results of any course and batch of students, there is no scope to accept the form of any other candidates after. So therefore, the results, after the results are published, then the review application form was given. We cannot approve. This is the reply to clause regular ordinance 15. We have given to him, even though it was at such a belated stage, we could have remained silent. But I have taken instructions. If there was any scope, I would have made that submission. There is none. I would have to go almost 40 candidates before him.
Your Lordship, I have something to say. I have something to say.
It will never end.
No, I only take 5 minutes. Only take 5 minutes. First point, what he had said, that with regards to the my filing of the second semester application after 1 year, just I've already said this before this honorable court, that I have acted on the basis of the notification issued by the college, and the university is vicariously liable. Again, I'm repeating, because the payment has been made by me before the university directly. And on that very same date, 25th of April, my 4th semester application, which was submitted to, that was processed. Then when the university is checking while probably the university will be checking the accounts, that whose amount, whose money is this, they should have pulled the application, my application. That's what I'm saying. The university is vicariously liable, and I'm having proof for that. I've already showed your Lordship the relevant annexures. And I've also mentioned this process on page 15 of my affidavit in reply. How the University of Burdwan processes the entire review process. I have made point-wise 1, 2, 3, 4, and 5 on page 15 and 16 of my affidavit in reply. If you kindly, Lordship, if you just peruse once, affidavit in reply. And to his second point, first, kindly peruse. Shall I read, sir? The university initially publishes a notification inviting applications for review, following which the respective constituent college issues a corresponding notice specifying the timeline for submission of applications. In the present case, the constituent college issued such notice on 24th of April 2025, fixing 26th of April as the last date for submission of review applications for LLB. I have no fault, Lordship. I have no fault. I have acted on the basis of the notification which the college has made based on the notification. Now, when the actual notification was made, that's what I've already intimated your Lordship. It was not intimated to me through the reply email in the 17th 12th. Only I have come to know through this. If If they had intimated me, I have made a college to party and a separate thing would have followed. This is my first point. Now, second reply to his point that he had read both the replies in that email, but kindly come to page 20 of my affidavit in reply. They have misconstrued that. Yeah, I pardon your lordship. Kindly first come to page 19, the last para, then 20. Page 19, last para. I'll read it out. As made in paragraph number 5 of the affidavit in opposition is a matter of record only to the extent of receipt of communications and issuance of the reply email dated 17/12/2025. However, the petitioner states that the said contention has been misconstrued and presented in a manner that distorts the true factual position. The correct facts are set out herein below. That is next on page 20. The petitioner has submitted one RTA application dated 26/10/2025. I repeat, it's a separate RTA application dated 26/10/2025 by speed post addressed to the SPIO of the university, which pertained to an unrelated matter and to the present issue as unrelated matter to the present issue. However, a part of the reply thereto was subsequently and belatedly furnished by the Controller's Office through his reply email dated 17/12/2025, having referred to as reply number 1. Now, this reply number 1 has no connection with this present issue. What he has misconstrued. Only the reply number 2, that is separately the petitioner submitted a written representation dated 6/12, and the same reply email having referred to as reply number 2. Now, my point is,
your 5 minutes of.
I almost finished, almost ended, your lordship. I'm taking a little bit time because the matter is this much big. The thing is that there is no deliberation. I again repeat, there is no deliberation, no meeting convened as per the Ordinance 15, because in their affidavit on opposition, they have mentioned on one para, I need to check the para, that on 13th of Jan, there is a meeting or there is a decision for this closure notice on 15th, but they have not provided any documentary evidence, nothing in support of their contention, your lordship. So my prayer is, and one more thing, your lordship, last, my preliminary objection to their affidavit, they have not, as per law, due authorization letter from these 3 respondents. This is respondents number 1, 2, and 3. I have also forwarded the Burdwan University Act, section 10 of 7, along with my ordinance. Kindly have a look, your lordship. Lordship, if you kindly look at the BU Act, I have already submitted with along with another document with the BU ordinance. Ordinance's সাথে আছে, if your lordship, ordinance's সাথে আরেকটা document আছে. If you kindly see section 10 of 7, section 22 of 2, 23 of subsection 15, and
come back tomorrow. Come back tomorrow.
No, this is the last point, your lordship. Last point. If you construe and read and construe these 3 legal points, the authority they are saying the trust officer.
Come back tomorrow. We hear you. Mr. Bihani, 4 p.m. tomorrow.
Kindly consider, sir. Kindly.
Yes, tomorrow.
My hardship, kindly consider.
Tomorrow, 4 p.m.
Sir, tomorrow, sir.
All your hard.
There is no more time. I'm ending, lordship. Kindly pass the order. Kindly, no more time tomorrow, your lordship. Kindly consider this. Kindly. Just I wanted to say that the authorization was not there.
Thank you.